ಹೌದು. ಕೋರ್ಟ್ ಕನೆಕ್ಟ್ ಮಾಡಿಲ್ಲ ಅದು. ಒನ್ ವೀಕ್
ನಿಂಕಲ್ಲ ಡಿವೈಡ್ ಯಾಕೋಟ ಹೌದಾ
ಅಟ್ಲೀಸ್ಟ್ ಕೊಡ್ರಪ್ಪ.
You are using device audio ಅಂತ ಬರ್ತಾ ಇದೆ. ಹೌದಲ್ಲ ಬಾಬಾ.
ಗುರುಗಳು ನೋಡ್ತೀವಿ. ಬಟ್ ಅಂತ ಗುರು ಗುರುಸ್ತಾರ
ಅರ್ಜೆಂಟ್ ಟೈಮ್ ಆಯ್ತು. ಗುರುಗ ಹೆಜ್ಜೆ ಪದೇ ಬಿಟ್ಟು
ಅಯ್ಯೋ ಅದು ದೊಡ್ಡ ಕಾಪಿಂಗ್ 3 ದೊಡ್ಡ ಕಷ್ಟ ಆಗ್ಬಿಟ್ಟಿದೆ. ಮಾಡ್ಕೊಡ್ತೀನಿ ಅಣ್ಣ. ಅಪ್ಲೈ ಮಾಡಷ್ಟು ದಿವಸ ಆಗಿದೆ. ಯಾರ ಅವ್ರಾ?
Put up, sir. Put up, sir. Put up, sir. No, put up. Put up, sir.
On Monday for admission.
What is the
Matters.
urgency? Give urgency is tomorrow. Otherwise, it will come within that week. Yes.
It's not an injunction. I'll put injunction entire law, put 80 crores. Doesn't decide which portion.
When that injunction order has been passed? Right. Monday.
With lordships kindly, Lord, may I make one submission, Lord?
Yeah. What is that urgency for interim inspection? Next week. What has happened to the trial court? Rejected. Tuesday. Yes, Tuesday. Tuesday. Yeah. Give arrow. You plaintiff. ನಿಮ್ಮನಂಗೆ ವಿಕ್ ಮಾಡ್ತಾರ ಏನ್ ಸ್ಟೇ ಇತ್ತು ಮಂಡೇ ನೋಡಿ No, there is no urgency, Mr. What is that urgency? You are not explaining. No, what is that order in that trial court you are challenging? When it is rejected? Friday. Tuesday. Yes.
Your lordship.
With lordships kindly, may I make one submission, Lord? Lord, serial number 32, your lordship.
Wait. We'll call page wise.
Please.
Page number 1, serial number 192. Number 2, serial number 3 to 5. Page number 3, serial number 6 to 9. Page number 4, serial number 10 to 30. Page number 5, serial number 14 to 18. 6, serial number 19 to 26. Page number 7, serial number 27 to 31.
Yes.
Narayan.
The request of counsel for the appellant. Use this matter next week. 2 weeks. Yes. 28. Yes. At the request of counsel for that appellant. Use this matter next week.
Page number 8, serial number 32 to 37.
35.
Lord, serial number 32, your lordship.
Maybe had on Tuesday or Wednesday.
35, Kashyap and Nayak.
IA for vacating. Have you
I've got the respondent, the date may be fixed.
next week. At the request of counsel for appellant. Use this matter next week.
With your lordships kindly.
Serial number, Lord, serial number 32, your
The
lordship.
date may be fixed. Tuesday or Wednesday.
Week. Yes. Or today. Yes.
With your
Lord,
lordships
serial number
kindly.
32, my lord. Lord, I am requesting for appellant counsel, my lord, serial number 32. It could be held up to 2 weeks for some personal inconvenience, my lord. Mallikarjun contractor, my lord, request for 2 weeks
The
time.
request of counsel for the appellant. Use this matter up to 2 weeks.
My lord, with your lordships kindly, with regard to serial number 33, my lord. I am for the appellant.
Wait. Yes, Mr.
Serial number 33, my lord.
Yes, Mr. Subhash, what do you want?
My lord, these two things I just wanted to place it before your lordships. The first one is the matter had come up on 17/4/23. On that day, their lordship was pleased to fix the date as 7/6/23 for final disposal. But the registry did not list the case on 7/6/23 because they had lost the file. Subsequently, a request was made. I assisted them to rebuild the file and all that. Then on the 17/4/23 itself, I had brought it to your lordships, their lordships kind attention that interim order had to be continued, and their lordship had looked into the papers and said he would do it, but somehow records were lost and everything was lost. And again on 27/6/23 it has come. That day, the respondent counsel submitted that this matter has to be heard by a division bench because it's a commercial transaction. They want to file an application, which they have not done it. But when the matter was tried before the trial court, it was not before the commercial court. I don't know how it has to go before a division bench. Anyway, they have not filed any application for that matter. Another request that I want to place it before lordship is this, my lord. Right from the beginning, senior counsel has been engaged in this case. Your lordship will not hear that senior counsel. He was your lordship senior.
Yes. Then I have to say not before me. Yes.
Yes, my lord. I'm sorry for this.
Yes. No. That's yes. Not before me. Since there is an urgency, registry is directed to take necessary order from Honorable Chief Justice, post this matter before the appropriate bench Monday.
In the interim order was there, not to indict any new dealer. That's all the interim order that was placed.
If interim order, if any granted earlier, is extended till next date of it.
Great.
37. ಇದ್ರಲ್ಲಿ ಏನ್ ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿದೆಯಾ At the request of counsel for the appellant, call this matter along with that so next week. 36. On depositing of 25 lakhs. Interim order is there. Yes. Have you informed other side?
I will inform my lord.
At the request of counsel for the appellant, please this matter next week.
Number 9, serial number 38 to 43. Number 10, serial number 44 to 49. Serial number 45, Mitsubishi MK.
Yes. You are appearing for whom, Mr.? Yes. At the request of counsel for the respondent, please this matter of 2 weeks. Next week will come.
I tried an IA for stay. Today they have informed me, therefore, my lord.
Next week.
7th or 8th.
Next week.
One submission.
LR already. 7th or 8th, my lord.
Where is that LR? Is there any order? That
She is already on record as a defendant, as a respondent in the matter.
R7 is dead.
R7 is dead. The sole surviving heir is R6, who's already on record.
Should you not file then a memo?
I'll file a memo.
Then, if you are there, it is there in your file, madam. Should you not be there in the court order? Yes, this matter next week. Yes, next week it will come.
Number 11, serial number 50 to 54.
Respondent. At the request of counsel for the respondent, please this matter next week. Serial number 50. Yes. I will inform other side. Yes, at the request of counsel for respondent number 1 to 3, please this matter next week.
serial number 55 to 58.
Serial number 56 for all. 56 for all.
Kumar KC.
Yes, you have any objection? On the request of counsel for the respondent, leave this matter next week.
Serial number 56. 56 for all.
Case number 30, serial number 59 to 61.
Serial number 60. Yeah, then
Madhav KP.
Yes.
we have it next week. because-
Oh, there is an application for vacating. Who is appearing for other side? Have you informed that? 60 or 61?
You know, they have filed an application.
At the request of counsel for the appellant, leave this matter of 2 weeks.
Next week from the state.
Next week. Yes.
Indian model implementation.
This is how that, Mr. You have to inform other side. Yes.
Inform them to
Interim order granted earlier is extended till next date of hearing.
the line.
Yes.
Matters.
Yes, leave this matter at the request of counsel for the appellant, leave this matter Tuesday, next Tuesday. Wednesday. Yes.
Case number 14, serial number 62 to 64.
The request of counsel for the respondent, leave this matter next week.
My lords, appearing for appellant in serial number 62, my lords, there is an interim order. Kindly
No, interim order is not there.
No, my lord, there is an interim order, my lord. The respondent has to mention a specific clause if they intend to sell the property. That was
No,
granted, my lord. On the last occasion
It-
also, it was extended.
It is not extended, then you wait that till the matter is called. He is saying that it is extended. Then I have to see that order sheet. Huh? Oh, I have to see and pass an order. I can't say that even though interim order is not there, I can say extended, yes. Wait, pass on.
Case number 15, serial number 65. Case number 1 for order, serial number 1, MG Suvarna, party in person.
Senate Council for party in person has filed a memo dated 6/9/2023, stating that two OS number 144 of 1888 itself has disposed of. It is sought for withdrawing the revision petition as not trust. Memo dated 6/9/2022 is taken on record. The above revision petition is dismissed as not trust.
Number 2, Abatement for petitioner.
I'm appealing for the appellant, my lord. My lord, I have complied with the office objections and I have converted to the CRP. Again, the office has raised the objection that 115, whether the appeal is maintainable under 115 of the CPC, my lord.
Yes, what is that order you are challenging?
This is the child court order, order 39, rule 1 and 2. There was an interim order granted, which was set aside by the appeal court when MA has been filed by the other side, my lord. I'm challenging that order, my lord, setting aside the interim order. So I have earlier filed MSA, my lord, and after that I converted into CRP. So now they are raising once more an objection stating 115 is not maintainable, my lord.
Yes.
It is maintainable, my lord. I have the CPC provision also.
No, 115 is that interim order which like in a final order.
It is not a final order. It is only against the cutting of the tree. It was not a. It's not. The suit is pertaining to partition, my lord.
Yes.
Suit is pertaining to partition and separate possession.
No, that Whether you have to file any MFA.
MFA Barala Swami, MFA won't come because we are challenging a senior division judge order in the MA. And 104 was the provision, MA has been filed. So civil revision petition is only maintainable, my lord. 115 CPC, may I read the provision, my lord?
Yes.
I'll just read it, my lord. It says, my lord, the High Court may call for the record of any of the case which has been decided by any court subordinate to such court and in which no appeal lies thereto. And if such subordinate court appears to have exercised a jurisdiction not vested in it by law, or to have failed or exercised its jurisdiction so vested, or to have acted in exercise of its jurisdiction illegally or material irregularity, High Court may make such order in the case as it thinks fit, provided that High Court shall not under this section vary or reverse any order which made or any order deciding an issue
That
in
is
the
what
course
that-
of a suit.
There is no appeal lies that you have to, yes, we will have it tomorrow.
Tomorrow.
Yeah.
Very well.
Matter tomorrow. You have completed the office objection?
I have completed all other office objection. It's only on this provision it's listed, madam.
Yes, tomorrow.
Obliged, madam.
Narasimharaju for petitioner, T. Basuraj.
Yes. Furnishing a plea of correct address. Issuing notice to R1 to RF. Huh? Why? What is that suit for? Hmm.
The property was mortgaged to the bank.
Now, what is the order now you are challenging?
Order challenging the rejection of client is not for.
It has been dismissed. Yes. Learned counsel for. Yes. Learned counsel for that appellant has filed a memo dated 3/8/2023. Seeking dispensation of service of notice to respondent number 3 and 5. Memo dated 3/8/2023 is taken on record. Notice to R3 and R5 is dispensed at the risk of the petitioner. Government advocate is directed to take notice for respondent number 7. Learned counsel for the petitioner is directed to serve one set of copies of government advocate. Generic yes. R18. Where is that handsome man? ಒಂದು ಎರಡು ಮೂರು ನಾಲ್ಕು ಐದು ಜನಕ್ಕೆ ಮಾಡಿದ್ದೀರಾ? ಇದು 6 ಜನ. ಎಷ್ಟು ಜನ? 6 members. Yes. Learned counsel for the petitioner has filed a memo at 14/7/2023 producing acknowledgement having served the hand summons to LRs of respondent number 1. The same is taken on record. Office is directed to show the name of LRs in a cost list. Yes, inner ಇದೆ. is granted to by process to issue notice to R2. Now, if they are not received and filed an wakalat, again you have to take. Yes, with the in method. Week's time is granted to pay the process issue notice to respondent number 2. In addition, the petitioner is permitted to take out hand summons to respondent number 2. Yes.
Number 4, P. Seshagiri Rao for petitioner, R.S. Ravi.
Writing service of notice to R1.
R2 is concerned not be received. Both of them are brothers. They were common plaintiffs before the trial court. They are being represented by a common advocate. Again, I hand summons issue matter is it is not Ravichandran. The next saying that so the name is wrong on the hands.
We'll take once more.
I do it. Not my other can also take notice because they are common plaintiffs before the trial court. They are brothers. I'm having the and the affidavit is also there.
He naturally he will deny because it is not his name.
I tell there is a wife there denying also.
Yes.
Not should kindly see this is a matter not so where a suit for declaration not was filed by the same set of plaintiffs before. The suit dismissed not because the suit was rejected under order 7 to them. Thereafter not they did not prefer any appeal as against the original statement ending. Yet again, another suit for declaration is filed by removing one set of parties, and I was also a party. When you put in a party, the same set of facts are there, but not replicated in the plain. And not the fresh 7th level, I'm sorry, and fresh plain has been filed. This will be sought for rejection of the plain. Not on the ground, but the limitation may be there. That's the difference. But once a suit is rejected for the same set of belief.
No, what is the ground for rejection? There is no bar for filing in a second suit. Order 7, Rule 13.
Absolutely. The bar not is the liberty is granted not. For instance, we undervalue the plain. The plain is not submitted in the duplicate. Or other mandates of 7 Rule 11 not technically. This is not barred because of a law previously. And not it is bad because it is not disclosed a cause of action as against the remainder of the case. Then in that event, not suit will have to be carried up in another. Not previously the suit was rejected on the premise that the same was bad. Now,
then it cannot be even for it is barred under law. First time it is also barred under law.
Second time, not says, but we sit over in appeal. The court, not the trial court, sits over in appeal over the previous judgment.
No. See, when rejecting your application, what is the finding? They said that it is not barred under law. Or say,
the finding is this that the previous rejection is wrong, something like that. Running page.
It is undervalued.
I should just point.
Where is that order?
I should just point out the previous order before that. Last time the final was on but the reason it was
Yes.
it was because of this reason.
Where is that order?
Just pass on. I was a purchaser under a auction sale.
No, we'll see that order. What is that reason given?
There was a separate memo.
That memo, there is no any distinction.
We see internal page 11 of this order. The deputy
Petition to Honorable Court and CMP has directed petition for your company. All that service of notice, there is no memo. Yes.
That's right.
Yes. 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 Then the claim has to be rejected. In the present case on hand, itself covered in the claims for para 4. It resolves the defendant in the case which are raised and loans from the defendant. The amount of the defendant who has raised the societies who has paid to discharge the production of the defendant and different. This is only gone that DRT, there is an appeal is pending in the DRT, not on that limitation.
Limitation or undervaluation that was submitted.
Yes.
Is that the purchase made by the current petition. Petition not sponsor recovery certificate to the ages of the DRT. The court do not spend that if you have a dispute with respect to that, I think the best part would be to go before the DRT and have the same rectified if it is not in order. And on that ground, for want of jurisdiction, not previously the suit was rejected, which now stands culminated in form of petition. Now not, if you not see the clause title, the I don't intend to use the word mischief, not but the
Yes, you take out that notice to him, you will have it next week.
My only endeavor is this, not still then, there are other students, they were also commonly represented by advocate. But I would advocate. A defendant evidence case, pleading evidence, what is proceeding with the trial with a very quick pace. All I would request not let not the trial be precipitated. The appearance of the I will not.
No, 11th is there.
Yes,
We'll have it on 10th. We'll have it on 10th.
or 8th is also.
No, in the meantime, you have to serve the hand summons to that other respondent number 2.
Same.
If they don't want to take, we'll see that. Yes. If they don't want to take, then we'll see. There may be some this thing. Yes, who is appearing for respondent number 2, Mr.
RS Ravi.
Then why his name has been shown? It is 2023. This Ravi and the co anta irodu, not RS Ravi. Yes. Office is directed to. Read the name of RS Ravi for all 2. What is your name, Mr. Akash? Show the name of Akash Kumar Gowda. Akash Kumar Gowda. Learned counsel for the petitioner is permitted to take out hand summons to respondent number 1. Is this matter on 9th? Yes.
With me, the respondent number 1.
Akash. ಅದ್ ನಿಮ್ಮಂದ ಹಾಕ್ತಾರೆ ಬಿಡಿ ವಕಾಲತ್ ನೋಡ್ಬಿಟ್ಟು ಅವ್ರು ಹೇಳ್ತಿರೋದು ಬೇರೆ ಕುಡಿ. No, when you are taking that summons, you should have seen that. Now you can see if they made a mistake, you can. No, it is not there that mistake in that cost list, cost title. Then it is committed by someone. Yes, now they can be corrected. Yes. Yes.
Before a time frame so that I have it.
No, office is directed to permitted to take hand summons to respondent number 1. Office is directed to issue hand summons to that petitioner forthwith. Yes.
Number 5, Madhukar as per appellant, Natarajake.
Yes.
The view of the court notes answer, counsel appearing in the fact any.
It should be taken for deceased R2 since postal serve as deceased for first time. N deceased R2. Have you filed an application?
No, this is R is being represented by R1 and R3. That is his wife and brother.
Hmm.
They are on record, and they have been represented by a trial court counsel.
Hmm.
And it has been duly served the leave of this court on 7/7/2020. Okay, the trial court may
No, first, Mr. You have to file a memo,
Yes, no.
take an order that they have been treated as an LR.
Yes. And
After that, yes, next week. Yes, week's time is granted to do the needful.
he was not, and the trial court, let not be precipitated.
What is that trial court is going on?
It's going for stage of the dependent cross examination.
What are you doing from 2017?
Yes.
Yes, you wait that, yes. Value is less than 10 lakhs.
Same notification, same village, same.
No. What is that value in that suit, Mr. In that appeal before this court?
And also, 2,90,000 before this company. Only 1 lakh is awarded by the.
No, it is granting it's different. In that appeal, what was the value? It is less than 10 lakhs or this.
My lordship, as per this judgment, lordship.
Judgment ಬಂದ ಮೇಲೆ ಬೇರೆ ರೀ. See, value of your appeal is less than 10 lakhs. This court judgment can be cited before that civil court also, is it not? Now that value is less than 10 lakhs, this court has no jurisdiction. No, not ready to. No, see, valuation has to be considered on the basis of the suit, is it not? Not by go on changing that value, it cannot be changed. Suit, it has been valued less than 10 lakhs. What is that valuation you have made it? That has been taken by that court. Now for your convenience, you can't go on changing that. To pay the court fee, there you are showing in a less value. To see that this judgment is covered by this court, you are saying that value can be made just an higher. That cannot be. Value will be calculated on that basis. You can show this judgment before that first appellate court and get it allowed that appeal. Yes, what do you want? Aunt Liberty, take and return the this thing and represent, Mr. Why do you want? For what? Yes, for the request. Leave this matter of 3 weeks. Yes.
I am appear for the respondent, my lord. I am appear for the respondent, my lord.
Yes, what is
I
this
have
matter?
undertaking to file a wakalat for respondent, my lord, in this matter. I am the trial court advocate. I filed
yes.
the suit for injunctions, my lord. My name
Yes,
is.
sir, he will take notice. We'll have it next week.
I will take notice, my lord. I will take. I am filed so wakalat also. My name will be mentioned, my lord. Dhanappa P. Pani.
I am the owner of the property. Without a lease agreement, unsigned lease agreement, interim matter has been taken. I have been not heard in the matter. Prior portal an opportunity not to interfere in the interim matter. Non building owner. Non first floor. First floor only, second floor tenants. You ground floor.
What is that interim order?
Not to interfere with peaceful permission.
7. By way of temporary injunction restraining the peaceful possession of 24 of scheduled properties. Suit for injunction.
This agreement will amount for ವಾಪಸ್ ಕೊಡ್ತೀನಿ ನಾವು 5 ಲಕ್ಷ 20 ಲಕ್ಷ ಅಂತ ಡಿಸೈಡ್ ಆಗಿದೆ ಬಂದ್ರು 5 ಲಕ್ಷ ಕೊಟ್ಟು ಇನ್ನ ಮಿಕ್ಕಿದ 15 ಲಕ್ಷ ಕೊಡಲಿಲ್ಲ ನಾನು ಮತ್ತೆ ಅವರ ಅಮೌಂಟ್ ವಾಪಸ್ ಕೊಟ್ಟೆ ಖಾಲಿ ಮಾಡಿದ ಜೊತೆ ಬಂದು ಎಂಟ್ರಿ ಮಾಡ್ಕೊಂಡು ನಾನ್ ಬಿಲ್ಡಿಂಗ್ ನಾನೇ ಹೋಗಿದ್ದ ಮಾಡಿದ್ದೆ ಪೊಲೀಸ್ ಕಂಪ್ಲೇಂಟ್ ಆಗಿದೆ ಎಫ್ಐಆರ್ ಆಗಿದೆ.
You are the owner.
Owner.
They are the tenant. You have not filed any eviction petition.
Eviction petition ಹಾಕಿದ್ದೀನಿ.
ಏನಾಯ್ತು ಅದು? ಅಲ್ಲಿ you have no any interim order. No, only thing is that you cannot dispose that client.
That is okay. But going into the you don't for they comfortable and
Where is that application for temporary injunction? What is the prayer there, sir?
not to interfere.
To interfere ಅಂದ್ರೆ ಏನಂತೆ?
Interfere with possession.
This on please to judgment and degree permanent injunction against the defendant are there, not to disturb the peaceful possession of the plaintiff in respect of the suit scheduled property, not to disturb us.
ಇದು contemporary act ಇದೆ ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ತಾರೆ ಅಂತ ಬಂದು ನಾನು ಮನೆ ಹತ್ರ ಹೋಗಂಗಿಲ್ಲ ಇಂಪ್ಲಿಮೆಂಟ್ ಇತ್ತು.
No, you ಅವ್ರದ್ದು ಮನೆ ಬೌಂಡ್ರಿ ಬೇರೆ ನಿಮ್ದೇ ಬೇರೆವಲ್ಲ ಅಂದ್ರಿ.
you don't know first floor second floor ಬೇರೆ ಮನೆಗಳಿತ್ತು. ನಾನು ಮನೆ ಹತ್ರ ಹೋದ್ರೆ ನನಗೆ ಅದೇ ಪ್ರಾಬ್ಲಮ್. ಮೇಲ್ಗಡೆ ಟೆನೆಂಟ್ಸ್ ಇದ್ದಾರೆ.
You are not. Is it an ex parte or after hearing you?
ನನಗೆ ಆಪರ್ಚುನಿಟಿ ಕೊಟ್ಟಿದ್ರು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
Why?
Only plaintiff has been called in the matter.
You are not appeared.
ಕೆಳಗಡೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ I am the not advocate. ಬೇರೆ advocate.
Now we are not concerned with that advocate, Mr. We are concerned with the party, whether you are, no, whether he has appeared or not. If it is an ex parte, you have a remedy for seeking for an vacating. How that, Amata, you have been not, why you have not pointed out that if it is injunction is granted, I cannot enter my premises. Is it true, Mr. Danappa?
My lord, I am agreed for,
No,
there is
you-
no agreement.
No, you forget about all these things. He is in that first floor because of that injunction to that ground floor. He cannot enter his property.
The agreement was, my lord, after receiving the 33 rupees by the landlord, he has handed the position to the tenant.
What is that
Execute
document
the
to show that
lease agreement.
sir, you cannot
But
enter?
I
You
have
have
produced,
any
I have
photograph
produced the,
to show that?
I have produced the, that is a check, that is 33 lakh rupees. he has
That is not on
issued.
merit, Mr.
That was dishonor. After that, my lord, my
No,
lord,
your problem is that you are in that second floor, you cannot enter because of that there is an injunction to that first ground floor. Show me any photograph, I want to see antandre injunction illa, agreement illa anta. What is this, Mr.?
my lord, in the return statement, in the return
That office
statement,
is
in the
directed
return,
to show the name of.
My lord.
Yes, leave this matter next week. Yes, next week it will come. Yes.
my name may be shown, Danappa P. Pani.
Number 8, Kevin Narasimhan for appellant.
Writing service of notice.
Serial number 9, Manjula L for petitioner.
Yes, week's time is granted to comply that officer. Comply ಮಾಡ್ರಿ 3 ಸಾರಿ ಕೊಟ್ಟಿದೆ ಮಾಡಿಲ್ಲ ಇವು. Yes. Urgency ಇದ್ರೆ why you have not complied, Mr. Yes, Mr. Comply. I said I have granted 1 week's time. You comply it and move it tomorrow itself.
Number 10, Bharati M for petitioner.
Awaiting service of notice to respondent. Take hand summons. Now, which law says that serving in a council is in a service of notice? It is convenient. Advocate is denied. You take hand summons. No, no, this court. No, why that earlier this court has not granted interim order on 570? ಏನಾಯ್ತು ಡಿಲೇ ಏನಾಯ್ತು ಈಗ ಮತ್ತೆ then how can you entitle for interim order when delay is there? No, just answer that question. how you are entitled for a interim order when there is any delay? ಎಲ್ರಿ ಇದನ್ನ ಯಾಕೆ ತೋರಿಸಿದ್ರು ಡಿಲೇ ಯಾಕೆ ತೋರಿಸಿಲ್ಲ ಡಿಲೇ ತೋರಿಸ್ಕೊಟ್ಲ Yes. You want to take hand summons? Yes. Yeah.
In 2003, left me and gone, and in 2019, she came in place for the maintenance. After 8 years, she's coming back.
Yes.
So, in that regard, if you start with it, it's around 25,000.
Yes.
In execution, it's not quite good. There is an expense, other expenses are also different. I can't leave my sister who are paying maintenance. I can't leave my sister also. If I pay her only 25,000 my house rent, is mother. It's not possible. At least the amount can be reduced by two. I'll be paying from this month onwards. I'm ready to pay.
Yes. By service of notice to respondent. In addition, petitioner is permitted to take out hand summons to the respondent.
Application matter, serial number 11, Varun.
Serve it and move that. No, you can't understand, madam. You serve it tomorrow, you move it Monday. I have permitted all the councils to move before my court at 10:30. Yes.
Application matter, serial number 11, Varun Gowda for petitioner.
Yes. Yes, issue notice on IA 1 of 2023.
Serial number 12, Siddharth Suman for appellant, LS Venkata Krishna.
Yes. LRs of appellant. Daughter and son. IA 1 of 2023 is filed for continuation of delay of 325 days in filing an LR application. The LR of deceased appellant. There is that affidavit. For the reasons stated in the accompanying affidavit, delay of 325 days in filing an LR application is controlled. IA 1 of 2023 is allowed. Consequently, 2 of 2023 is allowed. Abatement is set aside. IA 3 of 2023 is allowed. LRs of deceased appellant is permitted to come on record. Learned counsel for the appellant is permitted to amend the complaint. Is it?
Number 30, Prakash M for appellant, connected matter. Gopal Krishnan.
See that appeal is filed by whom? Owner of the vehicle. Why? Now that who is appearing for insurance company? Security is appearing. Yes, why that delay of 2,131 days? There is, yes, none appear for the appellant. Is this matter? Witness. Yes.
Prakash Angadi BV for appellant.
Yes, what is this matter, Mr. What has happened to that district court? Arbitration appeal? Dismissed. Yes. Again, your delay. Yes, issue notice on IA. Huh? No, mister, there is an mistake. You take and summons. Yes, issue notice on IA 1 of 2023.
Number 15, Sumangala Yagami for petitioner, SN Bhatt.
Yes. What is that order we are challenging? Respondent is directed to maintain 5,000 each to that petitioner, 10,000 from the date of petition. Petition filed by hereby 20-year ballot. Respondent is hereby directed to pay the monthly maintenance of rupees 5 from each to the petitioner. In total, 10,000 from the date of petition. Petitioner number 2 is entitled for the maintenance till attaining majority ಅಷ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ. ಆರ್ಡರ್ ಇದೆಯಲ್ರಿ. That is different for his this thing. You don't want to maintain your wife. Who? Petitioner means your clients. Then we'll dismiss it. We'll record your submission that he is not available. Then he will dismiss it. He will pay that this thing. Is he paying that maintenance, madam? What is that entry model? Further proceedings. Hearing subject to the petitioner deposit is 50%. What is that criminal miscellaneous 634 of 2019 for what? Arrears of maintenance. ಅದೇನಾಗಿದೆ ಅದನ್ನು ಸ್ಟೇ ಮಾಡಿಸಿದ್ದೀರಾ, ದುಡ್ಡು ಕಟ್ಟೋದಿಲ್ಲ, ಪಾರ್ಟಿನೂ ಬರೋದಿಲ್ಲ. ವೈ ಡು ವಾಂಟ್ ಮೇಡಮ್? ಐ ವಿಲ್ ಡಿಸ್ಮಿಸ್ ಇಟ್. ಈವನ್ ದೇ ಆರ್ ನಾಟ್ ಅವೇರ್ ದಟ್ ವಾಟ್ ದೇ ಹ್ಯಾವ್ ಟು ಡೂ. ವೆರ್ ಇಸ್ ಯುವರ್ ಸೀನಿಯರ್ ಮೇಡಮ್? Madam, he is working in an engineer is different. He need not maintain your wife. He has to maintain his wife and his family. If you want to argue on that merit, I will consider. But you are saying that you have no instruction for that party. Then I will dismiss it on the delay itself. Yes, madam. You file an objection to that IA 1 of 19. Yes, on that basis we will dismiss it. At the request of counsel for respondent number 1, 2 to file an objection to IA 1 of 2019. Leave this matter next week. Anyhow, that we are dismissing, your presence is not necessary. Yes, next week. Next Thursday. For this matter, next Thursday, 2015. Serial number 15. Yes.
I moved the memo may not be complete.
Where is that order passed by depositing that amount? Court. That is not the issue. What is that order you are challenging here?
State may not
Petitioner has entitled monthly maintenance of 12,000. Where is that impugn order, Mr.? ಯಾವ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ ಈಗ? ಇದು did that family courts and dispose of the matter within page number? Issue 2. Petitioner is entitled monthly maintenance 12,000.
And 5,000 and 2 children. Totally 22,000. And this sum will go to my lord, state is in order, subject to my lord deposit 15,000.
12,000 petitioners are entitled monthly maintenance of 12,000.
Wife get 12,000. If you complete it, we have 5,000. 22,000.
Other, what more jana? 25,000. Illian entry madragide. What?
So that is that was the last day. So I had the advance application right. But at 5:45, my lord, the order was passed to you won't deposit. By that time, my lord, the account branch was closed. Next day morning, I went, my lord, at 11 o'clock.
You could have moved the court for extension of time there. ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಇಂಥ ದಿನನೇ ಕಟ್ಬೇಕಂತಲ್ಲ? Respondent wife is working so and so, learner council so and so, hence stay subject to the deposit within per month with all arrears within 1 month from continue to pay further maintenance without default till the next date of hearing. ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಇಂಥ ದಿನನೇ ಕಟ್ಟಬೇಕು ಅಂತ? ಮತ್ತೆ what are you doing for 1 month? For the petitioner submits that pursuant to that order dated 23/6/2023, he has a cash he wants to deposit in that family court. In view of the order dated 23/6/2023, the petitioner is permitted to deposit that amount in the family court on or before 7th. Yes. Accordingly, I at 2 of 2023 is seek for extension of deposit in that amount pursuant to that order dated so and so. Yes, he has been permitted to deposit that amount pursuant to that order dated so and so on or before 7th. Accordingly, I has disposed. Okay. 8 on or before 8.
Serial number 17, Virupaksha PH for petitioner, Sridhara K.
Appear for respondent in this matter.
Unfiling of the document with regarding to the identity of the property. Survey copy and yes. At the request of counsel for the petitioner, leave this matter next week. Interim order granted earlier is extended till next date of hearing.
Number 18, G. Balakrishna Shastri for petitioner, Nandish Gowda GB. Number 18,
Asura.
number 19, Dhanalakshmi Y for petitioner, Abhinav R.
Yes, madam. Suit for injunction.
My lord, serial number 19.
Yes.
My lord, serial number 19, my lord. I'm for
Yes.
R1 and R2. May I request matter to be taken up any date next week, my lord. Some personal inconvenience, my lord.
Now that on what ground you want to reject the claim? Your
No,
application for rejection has been dismissed by that. On what ground you are seeking for rejection? No, that notification for challenging acquisition is different. He is seeking for an opposition for injunction. He is not in a title declaration. Now, what is that finding of the trial court while rejecting your application? Now that let us see what they want. Yes,
My
Mr.
lord. Yes, my lord, any date, my lord, in the next week itself, my lord.
Yes, at the
Any
request of
date may kindly.
respondent, leaves this matter next week. Yes.
Oblige.
Interim order granted earlier is extended till next date of. You have an interim order. Yes, that is, you want that suit cannot be proceed. Now you have an interim order. Why do you worry? Like, you want time. Now why you are objecting for time? Yes. Yes.
Trustee Kalyan R for petitioner, K. Manjunatha.
No, this is suit for their injunction. This petition is filed by dependent petition. What is that order you are challenging? Your application for rejection is dismissed. On what ground you want to sort for rejection?
This is a appearance in the fourth or fifth level of litigation. But the plaintiff has suffered repeatedly not a degree. Even in the recent report, they have suffered a degree in RS, which was fine before this one.
So degree for what?
The degree for very intention. And there is a clear finding that I am in possession of the property and their appeal RSA can be dismissed. And one of the family members had my suit for the declaration based on the compromise decree obtained in lowest number 34/2007. That is where the 2006 34/2006. In that lowest 34/2006, court has held that the subsequent proceedings which was initiated by the plaintiffs. That is, there is a finding that the decree is illegal. Obtained by them is by plain fraud. They were sued for declaration, filed within 4 days. All the parties appeared before the court. It was referred for the mediation. In the mediation, prior to obtaining compromise, already there was 2 decrees against the plaintiff and his family members.
Now that earlier suit is filed against you.
Earlier suit was filed by me. Initially, I
No, that
for declaration.
as that plaintiff has filed a suit for injunction earlier.
Initially, I filed a suit for the declaration in voice number 360 for 1984 against the Panchayat people.
No, that is not. Now that
Kindly come to
you will come to that. What is that finding of the trial court?
last before going to the finding on the trial court, the last kindly come to page number 34 the claim. Yes.
Okay.
In this paragraph, plaintiff here is the owner in possession and enjoyment of the property bearing serial number 73. 171, 172, number 1, measuring east to west 150 feet. So 40 feet. The plaintiff derived safe under compromise decree. Passed in OS number 34 for 2006 before the first additional CH code Kolara. For a moment, pass on the Lord.
You just explain. You need not.
There is a finding. Therefore, I would like to.
What is the finding?
Judgment in OS number 34.
What is the finding? Just explain.
OS number 34. The subsequent that OS number 34. The compromise. Subsequently, in the law, this came to be filed in OS number 92 for 2011 by the beneficial family member.
See, now you are stopped that OS number 34 of 2006. They say that there is a compromise degree.
Compromise decree.
Is it true?
Yes. Yes. Subsequent proceedings. Is a compromise decree and has been declared as legal.
That is not by this suit.
Not in this suit.
Yes.
OS number is declared.
That's
The decree obtained in OS number 34 for 2006 as illegal.
yes.
That was challenged in appeal. That also came to be dismissed.
No, now that
Against which may not in appeal was filed before this one or court, this one or court has also dismissed. You Lordship may kindly for a moment.
you want to point only this point in that plain.
Therefore, their reliance is on their right is based on OS number 34 for 2006. Subsequent proceedings.
No, that I understood.
As illegal. That's all I would like to.
No, I accept what you said. You see, argue further. This is for an admission. I need not say what you said is accepted unless he is disputed.
There is a judgment, I'm saying. Judgment declared by the civil court, which has been confirmed by this court.
No, I am accepting your argument, Mr. You go further. That point is argued. No, I am not disputing that. When counsel said we will accept it. If further I need, I will see that this is only admission. Again, we are repeating that. Yes.
It's relevant to submit that. In OS number 175 by 2011, filed by the defendant number 1 and 2, the validity of compromise was called in question and it is not considered by the said suit And also in appeal number RA number 117/2019, arising out of this section, that the plaintiff is in lawful possession and enjoyment of the above said property. Said property, the plaintiff has constructed tile roof house measuring east to 36 feet and north to 40 feet on the western side portion without within the suit scheduled property. The Kata is standing in the name of the plaintiff. There is electric meter also in the suit scheduled property house which stands in the name of.
No, what you want to make out in this?
This is, I find the petition number 194 and 5. But super the declaration in consequence to you. The High Court in Police number 175/2011 held that since the already the decree OS number 34/2011 is declared illegal in the connected to. Therefore, I will not be entitled for seeking not finding on the plaintiff. Therefore, that prayer and prayer for declaration to declare I am the owner of the property. Right. However, a decree for injunction was granted. Against which I filed an appeal, in the appeal, the judgment passed by the High Court was confirmed. However, the finding recorded on one point was reversed by the first of plaintiff. Against which an RSA was filed before this court, and also below the respondents here in the plaintiff and other family members. After hearing all the parties below, the RSA is filed by the plaintiff and the family members. Both the RSAs admitting my RSA for consideration whether I am entitled for declaration of my title or not. So far as my possession is concerned, it is being confirmed by this honorable court in RSA. Therefore, having suffered the decree where there is already a finding record, he refers to a court melody all the RSAs which were the judgment passed by this honorable court in the first paragraph.
Yes.
In paragraph number 4.
No, now you want to show that there is already a finding that you are in the position.
I am in possession of the
Therefore, injunction suit cannot be maintainable. That is what that your argument. Yes, Mr. Now, what you say that earlier proceedings, there is a finding that he is already in the possession. Then what injunction can we get from you? Unless you prove that after the degree you have dispossessed him, then you have entered, then you are entitled for that.
That aspect is concerned.
Yes.
The properties are. Yes, that's fine.
Property in that OS number 175 is different in that.
Different. Yes, it's fine. I take your honor to the admitted fact in this civil division petition.
No, which is that property here involved?
As the petitioner's property is concerned.
Then we'll secure the records and here will. Is there any interim order granted earlier?
Yes, ma'am.
Yes. Or
For the first time, before this court, they are only submitting that the properties are entirely different.
see the records that
The consistent stand of the plaintiff court right from 1984.
Mr. Kalyan. See, if you produce that plaint in that 175, if you produce this plaint, we can make out that whether it's the same property or not. That is the simple thing. Yes, we'll see. Yes, we'll hear that. Yes. Or, yes, you serve a copy and file it in the counter. File it in the counter. Yes, I would admit. Post this matter for hearing. Interim order granted earlier is extended till next date of hearing. Yeah. Next week, you file it in that. File it in the counter after serving that. If that is shown that it is a different property, then it's sent up the matter. Yes. Post this matter. Ilandri will do one thing. You serve a copy, we will have it next week. Next week we'll see. If the same property, then you have no case. Otherwise, I will admit.
The contention taken by them.
No.
What is referred in the plaint? What they have referred.
Yes, we'll see next week.
Before the courts, they have filed the credit application in this and this. Their application will be rejected under the contract. Order which is lost. And that has to
Learned counsel for respondent wants to file additional documents. Let's leave this matter next week. Interim order granted earlier is extended till next date. Let us say all that has to be not seen in this rejection of claim. Only thing is that
Whatever they refer, we have to look into the only the governments of the claim. And whatever the judgment they have referred, if that is only.
no, that's in the averment of claims. You say that this is the suit 175 is the similar properties which has been involved in this. That has to be seen if it is true.
Yes.
Otherwise, then it is a case of trial. Yes. Next week. Next week you are from which place? Huh? Malore, I thought that you are coming from the. You have to come, not making an accommodation to the council who is coming from that within that other district. I thought that you are coming outside next week. Next week. If you want date, then you will take that on 23rd. Interim order granted earlier is extended till. Yes.
21, Omkara N for the petitioner, Usman P.
Oh, that's yes. What is that petitioner name? Where he has signed?
Yeah, yes.
What is his secretary? Yes, you have signed that.
For admission was dated on 19/7/2020. The order sheet dated 19/7/2020.
No, managing committee is represented by secretary. Yes.
The order sheet dated 19/7/2020.
No, that on merit we will see. But interim order, you have given that position. What interim order can be granted?
Release the order sheet dated 19/7/2020. This court.
19?
7/7.
Yes.
Date, give it here. It makes a submission.
It's true. See, if your client himself, no, I don't want, I want to give a charge. They say, no, you don't give it. Wait, mister. Wait, mister.
I have to ask. 8/2023. In the next. Kindly come to the fourth paragraph.
Yes, this one.
What has filed a memo? I think it is shown in the table.
1/8/2023. Yes.
Right copy, my lord. You don't have the page number, but presuming my lord, the page number is 4. What not under which I am supposed to have given charge, they are taken charge. That is dated 20/2020. Fourth paragraph.
Yes.
Challenging the dismissal of IAP. The office bearers and also the Honorable High Court of 26. So far, they are not been able to obtain any orders. Or intervention of legislation. They suppress the fact that they come before the court, they take time to find their objections and they comment what does the hand on that. So the argument that now being argued is that handing of charge renders this challenge again.
No, your secretary has been forced to sign that. Why? He is a secretary of that institution. Has he given police complaint?
Managing committee, it's not an institution. 2020, managing committee is appointed. That managing committee is represented is great.
Yes.
This managing committee order was set aside in 2023 for the first time without there being a notice.
No, Mohammed Ibrahim. He is that secretary who has signed this. Are you disputing this signature?
We are seeing it was in the question because there was no written order by this court. He said that they had short time to file their objections. We permitted that. We wanted the matter to be disposed on rights and not. We permitted a person but not filed a to enter appearance. We permitted.
No, that is, we are not disputing all these things, Mr. Then you have permitted them. Why you have given the charge? You could have said that matter is pending before the court.
This is what we said, my lord, but the Wakf court did not agree that there is no interim order. There is a my lord, we said I insisted that the matter be heard on rights itself, not an interim application, the entire case of rights.
ಆಯ್ತ್ರಿ ಒಪ್ಕೋಡ್ನವ್ರು ಏನ್ ಬಂದ್ಬಿಟ್ಟು ನಿಮ್ಮ ಹತ್ರ ಫೋರ್ಸ್ ಮಾಡಿ ಸೈನ್ ಹಾಕ್ಸ್ಕೊಂಡ್ರ ಯು ಶುಡ್
Can't, my lord, they are.
that is
They are-
at least if they have threatened you, you could have given a police complaint. All these defense cannot be made before the court, Mr.
Can be, my lord, can be. It's for this, my lord, with due respect. Your handover of the charge. I don't know why it's the. The request not that matter be heard on rights itself, right, sir?
Cannot be. We'll consider your interim prayer. Yes. Yes.
Yes, signed, yes, signed, under the seal of the institution.
Yes.
We granted it that we have been forced to sign.
Yes.
And the seal of, yes, sir.
Yes, yes, Mr. I heard. Yes. Which is the serial number?
21.
Serial number. Yes. Heard the learned counsel for the parties. Interim order. Learned counsel for the respondent has filed a memo dated 3/8/2023. Enclosing charge has been handed over by the secretary who is representing that petitioner managing committee. Its charge is already handed over. The petitioner is not entitled for any interim order. Handing over the charge is subject to the result of this writ petition. Huh? No, that what is the procedure? There they have to any evidence has to be. No, that what is this application? You have challenging that order of that 83. Yes, no, that your application order under that is vacated. Now that final order has to be passed. Then
Next week itself.
yes, we'll direct them to dispose. You need not take because court direction is there. When the order has been passed for this thing, which is that impugn order which is under challenge in the before the tribunal. Next D.
25/2023 is the order of the case.
Page
60.
Yes. Yes. Shall function in accordance with in view of so and so exercising the power, the Karnataka State Court withdraw the order dated so and so. That order dated 14/12/2020. What is that? Wait, Mr. One counsel is arguing why this type of practice. Page. Yes. Oh, there's appointment of committee. This committee has been appointed now that that has been withdrawn.
It has been withdrawn.
Yes.
So our contention number.
Appointed Sri Kalidas caretaker to that so and so. Till up. Your appointment is for until further orders or December 2023 or until further orders both.
Same around granted on page 64
Before. Yes. Now that has been vacated by this order.
There are two conditions.
No, I understood.
Two conditions.
No, see, last I understood that how they have played. I didn't understand why your secretary has signed. That I didn't understand. Yes. Yes. See, when you have filed a writ petition, then you need not, unless there is a court orders to say that this thing, if they are forcibly, you could have filed a complaint. Then you could have taken that is as a ground for rejecting their claim. Yes. But this revision petition is filed by that will say, what is the next date? It is fixed there. 17. Yes. Filed by the petitioner challenging order dated 23rd June 2023, passed by Karnataka Wakf Tribunal on application 10 of 2023, whereby application filed by the petitioner herein is dismissed. The case of the applicants that by order dated 14/12/2020, the Wakf Board, by exercising the power under section 32(2) of 232 subclass 2 subclass G of Wakf Act, has constituted the managing committee for the management of Masdi E. Biparayan Jamma Masdi Road, Bangalore 51, for a period of 3 years or until further orders. The Wakf Board, by order dated 25/1/2023, has withdrawn that order dated 14/12/2020 and appointed a caretaker. Being agreed by the same, the petitioner has filed application before Wakf Tribunal under section 83 of Wakf Act, and also obtain ex parte interim order, and also filed an application for stay of that impugn order dated 25/1/2023 and obtain the ex parte interim order. By order dated 23 June 2023, that is impugn order in this case, that Wakf Tribunal has rejected the application filed by the petitioner. Being agreed by the same, the petitioner has filed this petition, filed this revision petition. The respondent has appeared through caveat. Respondent number 3 has filed a memo dated 3/8/2023, enclosing the charge handed over by the secretary of the petitioner management. In view of the same, the petitioner is not entitled for relief sought in this petition. Under these circumstances, only relief can be granted is directing the Wakf Tribunal to dispose of the application number 10 of 2023 as expeditiously as possible, not later than end of this month. Yes. Accordingly, civil revision petition is disposed of, directing the Karnataka Wakf Tribunal to dispose of application number 10 of 2023 filed by the petitioner within end of this month Yes. Yes. Yes, within 60 days from today. Yes. No, that will be there. That is not relevant. Only relevant is that that if you take that, then it will affect, because that is if you are already taken the charge, the question of giving in a subsequent would not arise. Yes, learned. The respondent has filed a memo on the counsel for the respondent has filed a memo. Yes. It has a course there. Yes, the serial number is 21. 21, yes. All the counsel's name has been shown. Yes.
22, Milind Gange for petitioner, Tejaswini Rajkumar.
Yes.
This case is on the interpretation of today. To file with the for injunction.
Yeah.
Balance rate. We read section 8.
What is that? IA filed under order 7 rule of
7 and
rejection of.
the court has got to do the jurisdiction. That go before the city small bunch. That was the IA I have mentioned. That IA has been rejected. Taking conclusion or taking the based on the judgments of two judgments of this honorable court. What is the division bench? It says that this court has jurisdiction. The full bench says that it has got no jurisdiction, but still I find there is a gap between the two. Section 8. Small budget.
Yes, read.
Yes. Cognizance of suit by court of small causes. Section 1.
Yes.
A court of small causes shall not take cognizance of suit specified in the schedule as suits exempted from the cognizance of court of small causes. Well, then we have to go to schedule. We have to refer the schedule for 2 times. Then we are saying all the number 40, there are 40, I think 40 kinds of suit which are exempted from the cognizance taken by the courts of small causes.
Wait. I didn't read the schedule. Yes. Schedule. Yes. Yes. I got that schedule. Yes. I got that. Yes.
Yes. Then all the others are not. We are referring only to the
Yes. Class 4.
Before this in the suit will property or recovery of interest, but not including a suit for the judgment. There are 3 conditions. Condition number 1, when the property has been let under a lease or permitted to be occupied by a legal instrument.
Property has been let under a lease or permitted to be occupied by written instrument or oral. Yes.
The court of small causes would be competent. It is iron. The court of small causes would be competent to take cognizance of suits for the rent of the property. Rent of the property is mentioned. They are seeking the rent recovery of arrears of rent. Therefore, as these suits of the court of small causes. Now, the condition of
No, this is not that small cause court judgment. No, this is a civil court order.
A civil court order, yes. Now, when we go to subsection 2 of section 8, this also says
Now
that.
that, what is that, this thing?
Regarding the pecuniary jurisdiction, subclass 2 says. Yes. Subclass is subject to exceptions.
Now we are reading what?
8.
8-2. Yes.
Subject to the exceptions specified in the schedule, those exemptions. And the provisions of any other law for the time being imposed, all suits of civil nature of which the value does not exceed X amount, that is 2 lakh rupees. Velocity, 1 lakh rupees in India, any other India. Here, the pecuniary jurisdiction is also exempted from this one. It is said subject to the exemptions.
Yes.
This point was not argued before the lordship. So therefore, I will subject to the exceptions of the schedule. In the schedule to even section subclass 2.
No. Suits which have exempted under that schedule
Yes.
and that suits its value is more than 2 lakhs are not coming under that small class.
Now, what is the value is the question.
Yes.
Is the value is the rent or the whole of the thing? Then further it reads that
Yes.
the cognizance of suit of the rent of the property, number 2, second part.
Yes.
So rent only to be considered. Rent is definitely less than 2 lakh rupees.
That we have to see on that judgment.
Yes,
Any judgment on that
yes,
point.
certain
2 lakhs is for that only a rent or that value of the property.
value of the
The
value of the
provision of law for the
property.
timing to all suits of the civil nature of which the value does not exceed in 2 lakhs in Bengaluru city. Other places shall be cognized with the small cost provided the state government in consultation with. Now, where you have read that it is only rent.
Then it is article 4. It is in the schedule.
No, here it said,
B.
see, nature of which the value does not exceed in 2 lakhs.
Yes.
Value of the suit, where it said that rent.
Rent is in schedule. Article 4 and clause B.
Schedule.
Article 4.
Or,
B clause B. The court of small causes would be competent to take cognizance of the suit.
rent of the property ku cognizance ತಗೋಬಹುದು ಅಂತ. It is not in respect of value of the suit is defined under that, I think in the suit valuation.
Suit valuation. This point there was a complete understanding by the earlier courts that is that the value of the suit is only for the purposes of calculation of collecting the code fee. The section 41 of the code fee has got nothing to do with this. It is clear understanding, rather pending. Therefore, considering these two aspects of the matter, this needs to be considered. Rent means only the rent of
No, it is a value of the suit. It is not said rent.
value.
The legislator
Yes,
has not used the word 2 lakhs rupees rent. They could have said we should not exceeding that 2 lakhs of the rent. They used the word value. Value of the suit has been explained in so many judgments.
Yes,
You have the judgment of madam.
And God, I rely on the prayer in
Wait.
Here, in clause B, they would have said the suit value of the suit. It doesn't say it said only rent. This says rent.
Well, where?
Or
Or B, see, suit for the possession of the immutable property or for the recovery of any interest in such property, but not include the suit for ejectment, where that including the suit for ejectment, where that property has been. See, they can file in a suit even for the rent also. See, it is not for an ejectment. If there is any arrears of the rent. For that also they can file in a suit. That is what that they said.
Class B.
If they want to recover that this thing, they can file it. See, if it is value is more than 2 lakhs, it is out of the jurisdiction of that. You need not go for that.
Correct. It says that section 8.
No, Mr. Counsel. See, whether it is for a rent, ejectment, it is secondary. First, the value of the suit is more than 2 lakhs. It is out of the jurisdiction of the small class court. We need not go for that. Yes. Yes, I understood. Yes. 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 Yes.
The court of small charges would be competent to take cognizance. A suit for rent of the property. It can be anything. Where is it? It doesn't say that rent will be if it is more or if it is so much.
No, in casely, we need not scratch all these things. Your case first come to that pecuniary jurisdiction. If value is 2 lakhs, then small cause court is out. We need not whether rent, eviction, we need not go into that. You see that value of the suit more than 2 lakhs, small cause court has no jurisdiction. No need to be. Value of the suit has been decided in so many cases. Where is that example?
Subsection 2 of 8 starts with that only.
Yes.
Subject to the exceptions specified in the schedule.
Yes.
All the suits of rejectment. Will be exempted from.
See, subject to the text, exception specified in the schedule and to the provisions of any other law for the timing in the prose, to all suits of the civil nature which value does not exceed 2 lakhs specified in the schedule and which is excluded by any other law. If the value is does not exceeding 2 lakhs, small cause court has a jurisdiction. That is what that said.
Conjunction.
Exemption and exclusion is also includes the exemption given there. That 2 lakhs.
ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ದಾರೆ ಅದು ಬೇರೆ ಇನ್ಯಾವ್ದಾರ ಕಾನೂನಲ್ಲಿ ಏನಾರ ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡಿ ಸ್ಮಾಲ್ ಕಾಸ್ ಕೋರ್ಟಿಗೆ ಅಪೀಲ್ ಅಂತ ಹೇಳಿದ್ರೆ ಅದು ಮತ್ತೆ 2 ಲಕ್ಷದ ಒಳಗಡೆ ಇರ್ತಕ್ಕಂಥದ್ದು ಸ್ಮಾಲ್ ಕಾಸ್ ಕೋರ್ಟಿಗೆ ಬರುತ್ತೆ ಅಂತ. ದಟ್ ಈಸ್ ವಾಟ್ ದಟ್ ದೇ ಸೇ. You want to read again and again, you want to go for make out your case, I will grant 1 week's time. You can come and argue even next week also. At any time you can convince the court.
Yes.
Yes, this is very clear. Yes.
I request
The application is there.
No. Prima facie, you have not convinced me. For your convenience, I will grant even 1 week time. You get ready and argue. There is nothing on this. Yes, next week.
I submit my lord. In fact,
Yes.
it's very clear on the face of the letter. I filed the plaint. I filed the suit. And the plaint is very clear that I am seeking for eviction along with arrears of rents amounting to crores of rupees. The suit is of the year 2017.
Yes.
It was posted for arguments because evidence was not there.
Yes.
They reopened it. And now they are
No,
filing.
madam, I am not granting any imprimanda. Still, counsel wants to satisfy himself. Therefore, I will grant next week time. And the meantime, you also get that any judgment on that value.
Valuation.
Yes. Suit value and value of it. Yes, next week. Yes, at the request. Yes, at the request of counsel for the petitioner. Leave this matter of 2 weeks. Yes.
Now case for petitioner.
Yes, madam. Yes. Defendant degree. Oh, you are in a defendant. Tenant. Recovery of. Yes, you are recover. What is that amount you due? Now that directed to pay the total sum of rupees 1,38,316. What is your defense before that small cause court, madam? Where is that line? 40? Yes. Yes. Yeah. Para 8. Para 3. Yes. Now that he said, you have a due of 2,43,000. That is the mistake of the lawyer who has typed that. It is in a lag. And see, no, it should be 2,43,000. 2,43,876. Yes. 1,27,160.
60. Like 16,716.
Interest rate. Yes, let us see what is your defense return statement. Where is your return statement? Yes, I understood your argument. Where is your return statement? Kelly there. I want to see that return statement. Where is that return statement? Give the copy. Is there any admission regarding that? Yes, yes. You have pointed out me there is any difference in this pleading itself. No. What's your name? What's your name? You first give me that return statement, then we'll go to that judgment. Give that. See what is your admission in that return statement. Yes, I will return back to you. That who are you? You are medical agency, na? He's your this thing. No, he is a distributor. Yes. You have a business with him, but you are denying that. Yeah. Yes. Yes. Now you what you want? Show in that into order. Yes. Yes. Now, have you issued a check? Yes. Issue notice. They are order dated 18th April 2023. Caused by small cause court, Mysore, in SC number 15160 of 2022, subject to petitioner deposit 50% of the decretal amount within 4 weeks from today. Deposit before this court. The director to deposit 60,000 before this court. I will give a figure. Yes, deposit 60,000 within 4 weeks from today, subject to deposit. Yes. Tomorrow. Yes, it will apply. Yes. But memo. Do it, madam. Yes. Yes, Mr. Yes. Yes. No, that you plaintiff. Absent ಆಗಿದ್ದಾರೆ. Now that you maintain. Yes, is there any entry matter here? Yes, I will direct the parties to maintain status quo and dispose of the suit. Evidence. Sorry. This appeal is filed by plaintiff under Order 43, Rule 1R of CPC. Challenging order dated 25th February 2016, passed by 12th Additional City Civil Judge, Bangalore, in OS number 4241 of 2015. Thereby, application filed by the plaintiff under Order 39, Rule 1 and 2 is rejected. For the convenience of the parties, parties are referred to the ranking as per the trial court. Plaintiff has filed a suit for permanent injunction. Along with that application, along with that plaintiff, he has filed application under Order 39, Rule 1 and 2 After service of summons, after appearance of the defendant, trial court, after hearing that parties has dismissed that application filed under Order 39 Rule 1 and 2 by order dated 25th February 2016, being approved by the same, the plaintiff is before this court. The respondent defendant has served unrepresented. Learned counsel for the plaintiff appellant has submitted that now that suit is set down for evidence of the parties. Under these circumstances, only relief can be granted is parties are directed to be maintained status quo till the disposal of the suit. Accordingly, the appeal is allowed in part. Order dated 25th February 2016 is modified to the effect that parties are directed to maintain status quo in respect of suit scheduled property till the disposal of the suit. The trial court is directed to dispose of the suit as expeditiously as possible. Parties are directed to cooperate early disposal of the suit. All pending applications are disposed.
Number 25, Vijay Krishna Bhatt, M for appellant, M.
In this matter,
Yes, but
there is a connected appeal, my lord, in MFA
yes,
3654 of 2018.
yes, learned counsel for the appellant submits that this appeal may be called along with that so and so next week.
Yes, 3654 of 2018.
Yes, ma'am. Consider. Yes, consider SCG. Yes.
Six, Mithun GA for appellant, V. Vinod Reddy.
For appellant, learned counsel for the appellant submits that itself has been disposed of. Hence, appeal will not survive for consideration. Submission of learned counsel for the appellant is taken on record. The above appeal is dismissed having become infructuous. All pending applications are disposed of.
28 urgent, serial number 28. Balakrishna appellant, K. Chandranath Ariga.
Yes, Mr. He wants time. The request of counsel for the appellant. Please this matter next week.
Number 30, Srinivasa Murthy, S for appellant. Serial number 30, Srinivasa. Number 31, MR Irremated for appellant, Shanti Bhushan. Number 31.
Also.
Number 32, 33, urgent, serial number 34, Abhinay YT for appellant. 34, Abhinay YT.
Then you will admission plan. Also.
35, 36, 37, urgent, serial number 38, Kalyan R for appellant. Prabhu Puja, yes, connected matter. Serial number 38. Number 39, Vijay Kumar K for appellant, connected matter. Balaji Raghunathan.
Yes, what is this, Mr.?
Application is not to alienate the scheduled property. The other application I find is they should not do development activities on the property. They were carrying out development activities in spite of any suit.
Suit what?
Suit for the declaration and possession.
Yes. They are the developer.
At the
Now, what is the relationship between the plaintiff and defendant?
plaintiff is the salient holder for the land. The developer is claiming rights on the basis of a partition executed by so-called legal heirs after alienation of the property. They
there
made
was.
a petition way back.
Hmm.
And that was lifted in the RTC. Ultimately, with that, they are saying, based on revenue record, we are the owner, and ultimately they execute the joint development agreement.
Hmm.
Based on that, developer starts activities.
You have purchased, you are the purchaser. You have purchased from whom?
I am purchasing from the.
One of the LRs of this.
Branding. So they are moving. My vendor has nothing to do with the.
What is the name of your vendor? Your vendor name?
My vendor is.
Chelurappa.
Name there.
That he has been granted by the land.
It's the mirror grant.
Yes. Now, what is that sources of title of the defendant?
Defendant is claiming through another grantee.
They are also claiming under the grantee. There are two grantees. Have they produced that grant certificate? You have produced that.
I produced the same thing. And
No.
subsequently,
Right of your vendor.
regranting.
Regrant certificate. It is in vendor favor. They have not produced any document.
That's what the document. They got no document to show. They have got a lease deed which they refer a document.
Is there any interim order here?
Interim order is already granted not to alienate.
No, here, this court.
No.
Yes, none appear. Leave this matter of 2 weeks.
Prashant Chandra, yes, sir.
Yes, Prashant.
So the appeals arise from a common order. It's a suit for injunction.
Yes.
Both requires to be heard together.
Where is that other appeal?
50-21 of it. Other KV file ಮಾಡಿದ್ದಾರೆ. We have served the copy.
Learned counsel for the appellant submits that his appeal may be called along with that MFA owns. Next week.
Number 41, M. Sudhakar Pai for appellant.
Appellant.
Yes, Mr.
Sir. Suit is not for part.
What's your,
For easy reference, the genealogy I have produced.
no, what is that by your application for?
Application number stating respondent number 3 hearing. That is defendant number 4 in the suit. Not to lease out the properties. That is rejected. But
Who is he?
he is one of the owners.
Co-owners.
Yes. But he is creating interest. He had already let out a premises, vacant portion of the property substantially. They have vacated. He pays 56 to kindly introduce. Number 5, and what dated 21/2/2023 by Mandavi Motors. Subsequently, they are deleted. The defendant number 1, so and so, was only a lesser of the portion of the plaintiff's property. Surrender the premises. That government is likely to lease out the fresh, and he said his state third party interest for long term lease will not is granted the property. He has only one.
Let him deposit that amount before the court. You will also get benefit. Otherwise, it will be vacant. Nobody will get benefit. Is it not? See, if you kept vacant, you are also having a share in that property.
Yes.
Then nobody will get any benefit. That is. Otherwise, we don't know when suit will decide. Properties become waste.
While deciding this application, the trial court goes on merits of the case. And earlier I had.
See, even I can say that part is to maintain status quo. Purpose will not serve. Both will not get any benefit by. See, if it is Mandavi Motors and Tandra, then it is in a big this thing property. What was the rent they are paying earlier?
It is private arrangement between the court, the third.
No, approximately, according to your information, what is the rent? Let him do it and deposit that amount before the court every month if you want to lease it, because it is a joint family.
Now he has not leased
No.
to anybody.
Now you
Now
are,
the entire property is vacant.
no, that even, I'm saying that either of them has to lease it and get some money. Why do you waste on that? Parties should get the money.
Nobody wants to lease these things. Money, let till the disposal period, let him not create third party.
No, I will say parties to maintain status quo, let him appear, then we'll see other side. Yes.
And the Lord, only third respondent, the Lord.
He's
I'm
correct.
seeking relief. R3. In the
No, I'm saying that you also not to lease out the property.
It's a right.
Therefore, all the parties are directed to maintain status quo.
Lord, in the application, he sought only against defendant number 4, which is respondent number 3.
No, I'm passing an interim order. I'm not passing any final order.
Yes.
I can restrain all that parties to be maintain status quo.
Lord, one moment, Lord, you are not kindly turn to my application.
No, that is true.
46.
No, I'm not deciding on your application. This court can grant any interim order which is protecting the interest of the parties. If I grant parties to maintain status quo, that may affect any rights. If parties affected right, they can seek for modification. Otherwise, tomorrow your party can lease off. That can be affected, yes. Issue notice.
For other respondents, I am seeking dispensation.
Parties are directed to maintain status. Issue notice. Learned counsel for
Only to R3.
learned counsel for petitioner appellant filed a memo seeking dispensation of service of notice to 1 to 4 to
10.
4 to 10. Memo is taken on record. Notice to respondent number 1 and 2 and 4 to 10 is dispensed. Issue emergent notice to respondent number 3. Parties are directed to maintain status quo in respect of suit scheduled property till next date of hearing. Appellant. Yes.
Number 43, one case for advocate.
Yes. Announcement. Yes, we'll admit it, call for records. Announcement. Yellow is 45. Reference photo. $25,000. Yes, madam. Please. ಇದಕ್ಕೆ ಎಲ್ಲಿಂದ ಕೊಟ್ಟಿದ್ದಾರೆ ಇವರಿಗೆ ಎಲ್ಲರಿಗೂ ಕಾಮನ್ ಆರ್ಡರ್ ಮಾಡೋದು ಇಸ್ ಇಟ್ ಟ್ರೂ ಮೇಡಮ್ that what is the document to show that it is 1990? Records ಬಂದಿದೆಯಾ? Yes, heard. Award Allah, position has been taken. Nineteen? 90. Then what is that the trial court has given from 1999? The land acquisition officer issued section 9 award was in passed on 1999. It has claimed that they are also entered to additional market value. So and so. ಎಲ್ಲಿದೆ? Page number? Serial number? ಅಲ್ಲ ನಿಮ್ದು LIC ನಂಬರ್ ಯಾವುದು? 206 15 par 2 10 guntas. 1990 ಏನದು? Date of taking a possession 1990 ಹಾಕಿದಾರಲ್ಲ? ನಿಮ್ದು 1990 ಹಾಕಿದಾರಲ್ಲ? ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಎಲ್ಲಿದೆ ಕ್ಯಾಲ್ಕುಲೇಷನ್? ಅಷ್ಟೇ ಹೇಳಿದ್ದಾರೆ. From the date of taking a possession they will calculate. It is not from 1999 where they have said 1999. See, in your case column for taking a possession they said 1990. While calculating they will take that 1990 only. See, yes, hard. Yes, let us see that. Yes. Yes.
Number 44. Number 44.
Yes. The request of counsel for the appellant. Please this matter next week. Yes.
Serial number 45 adjourned. Serial number 46 Prashant HS for appellant.
Good for
Declaration position and next.
no, what that regular appellate court has remanded that matter.
Enough material not on record indicates not that the disputed court was found only in the year 2012.
You are a plaintiff.
I am the plaintiff. I am the actual absolute owner of the property. Government cannot without acquisition proceedings, not without the compensation. If wants to take over not the property. This is there will not be.
Now that you are why it has been remanded?
Remanded only by saying not written said, not remanded. They take up a contention from about 30-40 years not be subject to what is being used. Only that contention not be subject to not.
Who has taken that contention?
The defendants.
Have filed an appeal.
But they have paid to prove not that it was in its part.
Filed the written statement before the trial court.
Filed.
Yes. Now what has happened?
No, not trial court not is going ahead.
Yes. Issue notice. Stay of further proceedings in YS number 26 of 2000. No, the stay of further proceedings in the suit. Stay of further proceedings in YS number 26 of 2014. Pending before Pending before senior civil judge and JMFC court Sorba till next date of hearing. Issue emergent notice. This government, Jilla Panchayat ki gala barala.
Santa Lakshmi HV for petitioner. Number 47.
Also,
Number 48. Irfan Vatrappa.
also,
Number 49. Vasanta Madhav, yes. Number 49.
The matter is, the respondent has been filed a petition before the vice was not.
what is this non-filing of acknowledgement?
I think it's complex. Last time, I submitted that the entire amount is paid till, July 2023. I gave the particulars to the-
Element of settlement ಆಯ್ತಾ?
It's in the final process. Matter is now in family court, Mysore for decree of favors. It is posted in this month only. The chance of matter is.
Yes, at the request of counsel for petitioner, release this matter after 2 weeks.
Hearing matter, serial number 50 adjourned, serial number 51. Yes, sir. Shiva Swami for petitioner.
It is not a parted before the court. No, is it a parted before the court? Where is that order for parted? Yeah, time thandiddare. It is in a parted, I don't think it will posted before me.
Regularly, it was really automatic.
Hmm.
We had asked, CF council had asked the agency for.
That box.
Again, not made different also because there was especially
But he will get back that, now somebody has taken time. File has gone. We'll get back and see. Yes.
Yes, sir. Shiva Swami for petitioner.
Which one, Mr.? 51, you are appearing for? So,
Serial number 52 adjourned, serial number 53. Ramesh Chandra for petitioner. Manjunath HR.
yes, at the request of the parties, release this matter next week. Yes.
MB Inamdar for appellant. Central government standing committee.
Ready? Ready. Who is that Inamdar? Yes, at the request of the parties, release this matter next week.
Serial number 55 adjourned, serial number 56. Steppa for appellant. MS Raghavendra Prasad. 56. Number 57, 20 cases for appellant, Sir Ananta Krishnamurthy. Number 58, B.S. Nagaraj for appellant, government advocate.
What is this, mister? No, that is why day after 2 days. Where is Nagraj? Password. Yes, password.
Number 59, 60 at the. Number 61, Sagar BB for appellant, K. Vijay Kumar. Number 61.
Yes. What is this, mister? Yes, where is that order? Plaintiff or a defendant?
Defendant.
Suit for? Why you have not appeared?
The first defendant cannot basically is the brother of the defendant. Service of someone cannot see appears. He not the both defendant cannot enter the appearance. The advocate cannot engage on behalf of the court defendant cannot suppose also on the advice cannot of the first defendant. He is my step brother. Cannot see the person paid in him. Cannot see does not contest the data cannot see against the court. That part cannot be relationship cannot be disputed. The content that cannot that the plaintiff cannot have
Have you filed any complaint against your advocate? He has colluded with the.
no, pollution cannot, I will not do that.
No, this is the matter which has been heard last time. This is not the. Yes. 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 Yes.
Soon instituted on 18/1/2013.
2013.
Yes. On 13 not soon someone starts the order and the date not fixed 19/2/2013.
Really, I have that order sheet has been produced here.
I have it with the appeal of the
Yeah. Yes, you just mentioned. We'll see.
So perhaps in 18/1/2013. And that day not the matter of the report. Perhaps summons is ordered to be served on the defendants. The date perhaps is fixed 19/2013.
Yes.
But on 19/2/2013, perhaps it is stated that D3 and D5 perhaps are served.
Yes.
Perhaps D1, 2, and 4 perhaps are unserved.
Yes.
However, now, the defendant number 1, perhaps even without service of notice, the entire appearance.
Yes.
Perhaps, and for insofar as D3 and D5 perhaps summons is ordered.
Yes.
Now, perhaps the D3 and D5 perhaps though are served, again unrepresented, they are expired.
Yes.
Insofar as D3 and 5 are concerned, the summons cannot be served, summons cannot be dispatched on 13th January 2019.
Yes.
Now, though the happened on 19, though the order 2013 is not dispatched, cannot still 13/2/2019.
Yes, mister, we'll give an opportunity for him, let him file a written statement.
On cost production,
Yes.
even to on cost. Yeah, so the defendant number 1 engaged in the consent.
Hmm.
I am using here with the art sheet.
Yes.
But 2/9/2013 order sheet. Inventory 4 5 local.
2/9?
Number 4 2/9/2013.
First page ಇದೆ. Yes.
The dependent number 29, the case was adjourned for filing of written statement of dependent 10/2013.
No, you are appearing for which defendant?
He is appearing for other than first dependent for all other.
Yes. Due to, yes.
Fourth dependent also is represented. Yes, engaged with the council. But thereafter, for filing written statement made adjourned for 1/10/2013, 5/11/2013, 2/11/2013. On 2/11/2013, they kindly look at order sheet. Written statement of D4 was taken as not paid. Yes. And case posted for plaintiff evidence. But please kindly appreciate here from 2/11/2013 to an opportunity not we let evidence the plaintiff PW1 5/3/2014. By 2/12/2013 written statement. Plaintiff examined on 5/3/2014 and exhibit P1 to P45 were marked. Counsel for defendant has not cross-examined the PW1, submits that he has no evidence. Evidence was closed and thereafter matter was heard and judgment was passed. Preliminary decree passed without the kindly what happened. Subsequent events are very important. Preliminary decree passed on 12/3/2013.
Yes.
Final decree proceedings, the respondent 7 have filed on 31/7/2014. Decree, non-preliminary decree was on 12/3/2013.
Yes.
Final decree proceedings initiated on 31/7/2014.
Yes.
The period between the 12/3 to 1.5 year more than is there from the date of placing ex parte by dependent number 4 more than 2 years. Opportunity more than the 90 days, beyond 90 days, the opportunity has been. The watching proceedings. In the FTP proceedings, what happened is also very important to note here. The wide order dated the FTP proceedings order sheet also I am placing before this honorable court. May kindly look at the order sheet here. There also the first in the initial stage notice was issued to the respondents. But may kindly very important to look at the notice order sheet in FTP. Notice served to R1. The date of 8/4/2014 may kindly look at pillar. 8/4/2015 alli order sheet alli. The notice to R1 to R4 not claimed. And thereafter petitioners based ex parte on 30/6/2016 here, 33/2016. Final decree proceedings were drawn. But wherein notice was responded to 5 RPID was served. They are not claimed, they are not received. Good opportunity, once again opportunity given, they are watching proceedings there. And after final decree was drawn on 33/2016. Let me kindly appreciate in the original suit they filed wakalat in 2000, that is 2/9/2013. Final decree drawn on 33/2016.
What is the decree passed by the?
Final decree suit for partition, equal states have been allotted by the court. But final decree drawing of the thereafter what happened? Final decree was registered. Thereafter, miscellaneous petition filed on 7/12/2017. Kindly appreciate. Final decree between the final decree and preliminary decree and miscellaneous petition date of miscellaneous petition filed on 7/12/2017. Kindly appreciate. 7 years.
What is the relationship between the parties? Why you have not disputed when that opportunity has been given? No, that see who will give that cost which has been incurred by the court. No, not that, Mr. Effort of that court, time of the court. You both together, club together and say that after 3 proceedings in 3 different courts can be set aside and send it back. See, you are represented by your counsel. When that ex parte order can be recalled, See, notice is not properly served. You have served, you are represented. If your advocate has not properly done, you give a complaint, but you are not ready to do it. Advocate said, we have no, cross-examination. Who has asked you to do it?
No, what happens is, suit is not contested by any of the defendants.
Yes.
Defendant number one, who happens to be the stepbrother, in collusion with the plaintiff.
You have given an opportunity. Why you have not contested? Forget about that.
That D4 minutes is the stepbrother minutes of the defendant number one.
Yes.
Whereas he reposes case minutes in defendant number one, to the effect that he would contest the suit. Because of that, he has not contested the suit independently. Now,
After the degree, you come to know that. After the degree, you come to know that your step brother has not contested.
Petition is filed on the date minutes they try to dispose as minutes. That is when minutes this miscellaneous petition is filed. It is dismissed on the premise that the trial courts come to a conclusion that even if the miscellaneous petition were to be allowed, they all are family members. Anyhow, they are bound to get a share. So that reason minutes is dismissed. It is minutes in the petition that is filed before the trial court, the court which passed the decree. It is specifically averred that there is no joint family in existence and the plaintiffs are not have. When such is the assertion made by the before the trial court would not have dismissed the petition on that premise, assuming that even if the petition were to be allowed, everyone would get a share. Now, with regard to service of summons, now on the first day, deeply and different they are just expired. The date of appearance was 19.
Place that all that order sheet.
Order sheet in there. Is affidavit. In affidavit, I have detailed every and there are part of state. Stay order was granted. They were okay with it.
No, now it is posted today for hearing.
For vacating of 3 months is concerned, I detailed affidavit is filed.
No, that order sheet, have you produced that? You produce the order sheet of that, this of.
And state as well as that all the whatever the stuff
You produce.
Certified are there, they are.
No, records has come. What is there? What I think is that FDPs, you have to produce that order.
FTP and miscellaneous without cross-examination, legal cross-examination is
Look
there.
at that, Mr.
In the cross-examination, original records with as well as I am also certified copies. That I am having, when we look at the cross-examination addition in the.
You file it that, I don't have any copy that.
Yes,
That is what that you serve a copy and file it, then we'll see.
original records, miscellaneous are there.
No, this is only in respect of that miscellaneous.
Miscellaneous, just remaining only 2 order sheet I have to place.
You have to place it. You place it next week. Yes.
Let me-
Next week, and next Thursday. Serve a copy to him and place it. Yes. Interim order granted earlier is extended to next date of. You have to explain each delay. Why you have not done. We'll see that after that.
Yes, sir. First minutes whether there was few service of some. Minutes complex minute whether minutes by or not.
No, then without serving the summons, how you have engaged the council?
Other defendants.
You are not engaged any council.
Other defendants are not engaged.
You are not engaged any council.
But defendant number 4 engages a council minutes, he does not contest it. Defendant number 2, 3 minutes, their minutes do not engage any other council, they are placed ex parte. Very first they are placed ex parte. The civil suit will no 3 days, no opportunity, only 1 time civil suit will not summons one served within the. It is served or it is served not in the validity. The served petition filed by both parties. That one of the parties appeared before the court by engaging the council. He is very well aware all the brothers and sisters, they are family. They are aware of the proceedings.
Now he is on the root of the matter. He is saying that in the suit itself, his summons is not served. That we'll see that on record.
Order sheet has to be seen to whether that service is due service or not to be considered. Length of 8 years proceedings concluded by a decree drawn, Tahsildar issued notice where notice was also received. A body work was the bifurcation of land in final decree proceedings. At the time of drawing up a final decree proceedings, court had executed appointed the commissioner.
Where is that order sheet of that suit? Order sheet of suit you have?
Yes.
What is that not duly served?
Lordship can see minutes 18/1/2013 minutes is executed minutes, and that is suit summons is ordered.
Yes.
Minutes 19/2013 minutes is the next minutes of minutes on that particular day, DP and D12 minutes are served minutes, they having to report their placed ex parte. Now minutes, though the order for issuance of summons minutes was made on 18/1/2013, but the court minutes dispatches the summons only on 13th February 2013 minutes of the date 19, long and the summons at 19. Now minutes your lordship can be seen, and it is served on 15/2/2013. 15/2/2013 minutes, from 15/2/2013 up to 19, there are 4 days. Now minutes are with 6 minutes contemplates that there must be reasonable time minutes for the party to enable them to enable the parties to appear to the court. Now
That when the suit has been disposed of? 19.
2017.
You have been served on 13/2/2013.
Yes, what is it? What Supreme Court says here, pendency of the party having acknowledgement of pendency of the suit is not relevant. What the party has to know, once he is placed ex parte, the next date of appearance, if he is not notified, if the not is improperly placed ex parte, then there is
Let us see, you produce that order sheet also.
very well produced.
Yes, because that records is not available. It is only applied court records is available. I think suits records is available. You produce that order sheet. Yes, let us produce this next week. Interim order granted earlier is extended till next date of hearing.
Sought for an adjournment. Because what has happened is that there is an interim order that was in operation.
Serial number 63.
62. 62. Pending before Justice HP Sandesh.
Yes.
Due to paucity of time on all the 4 hearings, the matter could not reach to us. The interim order was extended. However, on the previous date of hearing, it is at the time of the registry is paid to mention that the interim is word, but it is not mentioned in the order sheet.
You are not present on that day.
In the morning, the adjournment, and it was without intimation. Okay. And in the evening, when I made a submission, the honorable judge and the registry also informed that it will be extended. Because the interim order was granted on 19th of April. Subsequently, on all the 4 hearings, has been granted.
19th of April.
19, 2020. Justice, Honorable Justice S.R. Krishna Kumar had granted this order, and it is pending for final hearing. On all the 4 hearings, it has been extended. On the previous occasion, without information, it was adjourned minutes, and like I was waiting for the whole day. And
Yes, I am asking 19th.
19th of April.
19th April 2020.
2020.
23. Order granted by this court dated 18/4/2023 is extended till next date of hearing. Yes, read this matter after 2 weeks.
That's a date.
Yes, till next date of hearing, interim order is there. Yes.
Really, let's see if the 4 hearings will not come. Yes.
Next week. Yes, next week.
Number 63, Gagan as for appellants. Saravana S.
Yes.
Actual second. The matter is posted for final hearing by order dated 6/7/23. The order sheet number is dated 8/3/25.
Eight three.
Yes.
Yes.
This is the second appeal. without raising substantial question of law. Finally come to notes order dated 8/7/2022. Eight seven 22.
Yes.
Now, this court notice that substantial question law was not raised. The matters.
Due to the demand of the substantial question law not be therefore we sought cooperation to frame the substantial question. Submission is not a implement. There is no direction to post for order. Court said counsels for the appellant submits that due to the inadvertent substantial question of law is not framed, therefore he seeks short accommodation to frame the substantial question of law.
Therefore, the matter was kept in the stage of admission itself. Now, what happened was on 7/23, what was not brought before this court. Therefore, the matter is now proceeded for final hearing.
Yes.
The time of sorting was not brought notice to the court. What dated 8/7/22.
Substantial question of law is not framed. Yes, we will post it for admission.
Has already been admitted.
No, that the law is substantial question of law has to be framed for admitting that matter. It is a regular second appeal and miscellaneous. Huh? Give that. No, there is an order of this court.
Prior to that, matter had already been admitted by both administration.
No, that substantial question of law has to be framed. It is in a the law, then it has to be framed and it has to be posted for hearing. If law is that it not be required, then you can hear that. See, in RSA. No, only I have to see that law. I have also not across that. In that Workmen Compensation Act, you have to frame the substantial question of law in RSA. But MSC, I have to see that.
That we place it. In fact, we brought notice to this court notice.
Because this court has passed an order on that basis. Therefore, I will verify whether it is correct or not. Otherwise, we have to be heard that matter for hearing. Otherwise, we will frame the substantial question of law. Is it required under that appeal memorandum? He has to frame the substantial question of law.
So that we place it before this court. Right now, I am not having. What's my having?
Because I have not across any such this thing in that other matters also. When do you want? Next week. Yes, next week. Next week is missed next Thursday. Yes. Yes.
Serial number 64, post Varama for appellant.
Interim order granted earlier is extended till next date of hearing.
Serial number 64, post Varama for.
Yes.
Are we separate is in this?
Yes.
We are choosing one for bearing.
Yes.
Restraining the appellate defendant
Hmm.
from interfering with the possession of the plaintiff. The trial court will after hearing and considering the documentary evidence from the court. For this is the truth. Declared the truth of the plaintiff.
Yes.
As per the order dated.
What is the decree?
Decree is for permanent detention.
Yes.
It is a bare detention suit.
Yes.
Operating portion of the order is going to be.
Yes, I got it. It's signed from, yes, interfering.
Against this order. It is required.
Yes.
Before the respected court.
Yes.
In the RA number 504 of 2019.
Yes.
And during the pendency of the setup, the plate, the defending filed an application under part 1. To produce 2 documents which are subsequent to the filing of the suit.
Yes.
That application will be allowed by the judgment and decree dated 8/10/2021, it is included in this list. Right.
Yes.
Now, the question before your lordship, the question of law, it was framed by this on before your lordship when we see. Your lordship will get it. On 17/6/2022. Whether the district rate code was specified in allowing A number 3 and by regulate under R41 therefore by setting aside the different degree OS number 615 of dated 7/19 passed by the fourth edition will get which will in view of the provision contemplated finding of the district rate code is part in the clear in OS number 288 of 1987 filed by independent where it has been held.
No, that is different. If they have make out in a case for allowing that application, then it required for remand.
Yes, my respect to the-
Or that appellate court itself can ask that to get an evidence and.
Yes. Itself have recorded the evidence rather than demanding. Second submission record. The earlier suit filed by the very same defendant in OS 88 of 1997. A finding was recorded that she was not in possession of the associated property. Therefore, in view of the remand that judgment and decree passed in OS number 288 of 1997 is nullified. Therefore, the application did not have been allowed. My third submission will not. The affidavit filed by the defendant. That she
No, what is the documents he has produced?
2019 document which is nothing to do with the property in question. Because I can understand the suit your lordship can see was filed in the year 2012. Now she says that I could get the document of the year 2019 which shows that I have put up a construction schedule property. 2019 document that is a Tata in the schedule property.
No, but in 97 he has failed in the suit.
Yes. Suit of the year 1997. 2021, my lord, she, no, 10/10/2019, she came to know about the document.
Yes.
Much earlier, came to know about the central document. Therefore, subsequent document provision contemplated under Article 47, my lord, it is very clear. We are also trying to see Article 27, Article 41, 27. The provision contemplated under is a provision. The parties to an appeal does not be entitled to produce additional document, whether oral or documentary in the appellate court. But if the court from produce the appeal has refused to admit evidence, it ought to have been admitted. Now it is not the case that document was refused by the entire court because at that time document was not available.
Yes, read.
If the parties to an appeal do not get
Article 41.
Article 41 to 27. The clause A. 1 to 27.
Yes.
The parties to an appeal shall not be entitled to produce the additional document, whether oral or documentary in the appellate court. But if the court from whose decree the appeal is refused to admit the evidence, it admitted. The party seeking to produce additional evidence established that notwithstanding the exercise of due diligence, such evidence was not within his knowledge and exercise of due diligence be produced by him at the time when the decree appeared against was passed. Now, at that time, my lord, that document was not in existence.
Yes.
So, either under Article 41(1)(a) or B, she is not entitled to produce the document. B, your lordship can see the appellate court requires any document to be produced or any witness to be examined to enable to pronounce the judgment or for any other substantial cause. The appellate court may allow such evidence or document to be produced or witness to be examined. Now, here is a case where she suffered a secret in the earlier proceedings. Her suit was dismissed.
So is there any finding in that appellate court regarding that earlier decree?
Yes. the lordship kindly see. Binding only with regard to the application, my lord.
Yes.
Number 1, page number 26, your lordship kindly see.
Yes.
Item number 2, that is order 6, rule 9. That application came to be rejected. Now, the finding with regard to order 41, June 27, application.
Yes.
The lordship is getting, 39.
Yes.
Page number 39.
Yes.
It is pertinent to note that the applicant defendant has filed item number 3. And the court stated in the last edition evidence and to produce the edited document having certified copy of the survey state dated 10/10/2019 to 204/8. Certified copy of the survey is 8. Now, this on 10/10/2019. The last 10 days appreciate. Food of year 2012, this is a subsequent document. It did not have been relied upon or not have been filed. And the edition evidence is the above case in the issues of this. It stated that after the file along with the application that she has referred an appeal against the judgment and district asking for number 615 of 2012 by the court decisions related to it is stated that herself and her wedding are in possession of the subject property. Herself and her wedding has restricted the building in the subject property. She has recently came to know that survey of the state was done on 10/10/2019 at the base of the respond number 2 and said service discloses that buildings are constructed in survey number 2/8 which are shown in the state. The appellant defendant has also taken in defense that herself and her wedding Emma have constructed the above said building in survey number 2/4/8. She has recently obtained the said document. She did not have obtained the document earlier because the survey was done 10/10/2019. Said documents are getting based on merits. The said documents are also required to this court enable to the application are not allowed. Greater hardship will be brought to the and no hardship will because allow the application to make this up. The contract. The application stating that the application filed by the application is identity of the property had already been established. The documents property details are all the subsequent documents not related to the date of the which are being made back to the respondents. Now you are not should be aware second position of law and on the date of filing of whether she is in possession or not.
Yes.
Now in the year in this filed earlier we got that is 88 of 2017. The court has come to the conclusion that she is not in possession of the property.
Is there any discussion regarding that earlier suit?
Yes.
No, even assuming that there is a case of additional document,
Yes.
if earlier suit it is dismissed, it is no purpose will serve if you allow.
Exactly.
No, is that has been considered?
Yes, that was considered in paragraph number. It has not been.
What is that paragraph, issue number 3?
Like the trial court will.
First appellate court issue number.
Appellate court issue number 3.
Whether the improved judgment and degree required to be implied by this court. Committee on why they have discussed. Yes.
Number 3.
They have discussed. Will 2:30 continue. Who is your opponent? Yes, let us. Yes, we'll have it at 2:30, madam, afternoon. Yes. What is that urgency, ma'am? Which number? Hmm. Yes, 38. Respondent, you are for that appellant. Yes, sir, the request of counsel for the appellant is this matter of 2 weeks. Interim order granted earlier is extended till next date of hearing. Next week. Yes, next week. 1/8. At the request of counsel for the respondent next week. Yes, Mr. 42. Yes, pass over. You want? Yes. 2:30 will take, pass over. We'll take the 2:30. Yes. Yes, 2:30 will take, pass over, and then we'll go for an hearing. Matter. Yes, sir. Shall I read it? Then it is wrong. We'll mention it.
Court officer, serial number 60 adjourn ಆಯ್ತಾ?
Court officer. Court officer. Sir, serial number 35 adjourn ಆಗಿದೆ sir.
ಆಗಿದೆ ಮೇಡಮ್, ಬೆಳಿಗ್ಗೆ ಫಸ್ಟ್ ಅವರ್ ಅಲ್ಲೇ ಆಗಿದೆ.
ಸರ್, serial number 60.
60.
ಹೌದು. ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗಿದೆ ಸರ್ 60. ಕೋರ್ಟ್ ಆಫೀಸರ್ 60
ಡೇಟ್ ಏನು ಫಿಕ್ಸ್ ಆಗಿಲ್ಲ ಸರ್.
ಅಡ್ಜರ್ನಾ? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಪಾಸ್ ಆಗಿದೆ, ಅಡ್ಜರ್ನ್ ಆಗಿದೆಯಾ? ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
Number 30, Srinivasamurthy as per appellant. Number 30, Srinivasamurthy, yes.
None of here, lose this matter for 2 weeks.
Number 31, MR Limited for appellant, central government.
Next week. At the request of council for the appellant, lose this matter next week. Next week it will come. Why you want there? We're all practicing here only. Yes, outsiders is there, we can give a date, yes.
Number 34, YT for appellant.
This is the issue.
Non-filing of the documents.
I have to address on the background. Of the document. So that if the background of the case, we don't have the document.
Now, what is that order on 18/7/23?
What was passed, that we have to produce a document regarding the residence of the husband and the wife. There's no document in the trial court records.
Then court has directed.
This is an appeal. against issuance of the succession certificate.
Now, this court has directed you, you want to comply it or not?
You don't have the document. We check through the trial court records. We
You
don't have-
file an application for recalling that order. How can I overrule without that, mister? One court has passed an order. If changing the roster, you can say that, you can ignore that order. Now, government officials started not complying that high court order. Now, lawyers also started.
Coordinate bench was indicated that if you have the document from the.
It's an
lower-
order on record.
ಇಲ್ಲ, document ಇದ್ರೆ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರೆ document ಇಲ್ಲ lower court record.
That is not that order which says. Present, no such document is placed before this court. In the meanwhile, learned counsel for appellant is directed to produce the document to show that all of them were residing together and no such document is placed before this court. They have not said that in case if you have, either you have to file an application for recalling that order.
File an application.
Then we'll see your affidavit showing that there is no such document, then we can recall and yes. Next week. Yes.
Number 42, Anusha Helper, appellant.
Yes. Yes. Oh, you are a plaintiff or a defendant?
I'm the plaintiff.
Yes. Yes.
Legal opinion is about so that it's eight, other than 58.
Yes. Hundred and 15.
115.
Yes.
Third condition condition. If the document by the court, then the, not granted. Not consider not. So I am the daughter of Arjun. I find that suit for partition and separate possession. Now that a notice for the issue.
Yes.
And I have that notice where the party was not done.
Yes.
You have quite a repetition. In the repetition, there is a state. Given in the input.
Yes.
The hearing of the party. It's,
What is the respondent or don't connected to enable them complete that is. The interim order is, what is that interim order passed by this court?
that interim order is not this status.
Let us.
Status 2 minutes
Yes.
as paid for.
Now that your application for temporary injunction has.
Yes, on the count, section 34 is coming the way.
Yes.
There are two division benches.
No, this is not for rejection of claim.
They have sought for vacating an interim. This court said
Yes.
status quo shall be maintained till the final hearing.
Yes.
Now the trial court said
Issue
section
notice.
34 is coming in the way.
Issue notice. Parties are directed to maintain status quo till next date of hearing.
Number 47, Vasanta Lakshmi Lakshmi, petitioner. Number 47.
Yes. Yes, none appear. Please this matter of 2 weeks.
Number 48, Etnal Parasappa.
Also engaged in this, not keeping kindly taken next.
Yes. Request of counsel for the petitioner, leave this matter next week.
Number 51, yes, Shiva Swami for petitioner, M. Shiva Prakash.
Shivram, where is your opponent has come? Yes, you are ready. No parted. I have just heard him. Friday. Right. Then you can wait, let us see. I will come to that. Yes, yes, let's. Earlier suit, if your injunction is rejected, what is that? We'll see that when the matter is. Yes. Yes, tomorrow. Yes, leave this matter. Yes, tomorrow. Leave this matter tomorrow at the request of the parties. At the request of respondent. Yes.
I appeal to the petitioner.
Yes.
This is the first dependence petition.
Yes.
The suit is filed by one person called Nagaratnamma.
Wait, wait.
Yes.
Defendant number one appeal.
Yes.
No, this is the petition. Yes.
One Nagaratnamma files a suit.
Yes.
Is initially one person called Nagaratnamma files a suit
Yes.
seeking to set aside a deed of gift
Yes.
executed by her in my favor. Technically, the dispute is only between her and me.
Yes.
Now, this
Nagaratna and you.
Nagaratna and me. They actually originally it started. It's one property to me.
Yes.
Now, my lord, in that suit, she arranged a number of other people, including defendant number 6,
Yes.
which she said was her adopted son.
Yes.
Now, my lord, defendant number 6, during the original course of proceedings, defendant number.
Now, in that suit, what is her prayer?
You know the one prayer to declare the gift deed from her to me as wife.
Right. Yes.
In that suit, defendant number 6 is also brought under adopted son.
Yes.
We deny the adoption. Why? Because actually she did not have any children.
Yes.
She considered me and defendant number 5 as the foster daughter.
Yes.
And considered defendant number 6 as the adopted. This is the background of it. The adoption is denied by us.
Yes.
It's a matter of the suit.
Yes.
In the initial course of things, a transposition application comes to be filed to transpose defendant number 6's plaintiff number 2. Trial court rejects the transposition.
Yes.
Saying that after the dispute is only between these two people, comes before this son of people. When it comes before this son of people, transposition application comes to be allowed
Yes.
with certain conditions. The lordship will take page 50 of the paper. The repetition order starts at in page 40.
Yes.
Operative portion, page 50. 50.
Yes.
50 only order.
Yes.
Yes. Repetition is allowed. Impugned order stands quashed. Where in IA number 10, which is transposition, stands allowed. D6 is transposed as plaintiff number 2.
Yes.
Amendment to the plain to be carried out in trial court within 2 weeks from today. Written statement filed by defendant number 6 stands cut off. Additional plaintiff shall proceed with the case of the original plaintiff and he will not have any right to plead his own case since he has only been formally pleaded as a party to the suit.
Yes.
He
What
has
is
no
that?
locus at all.
No, he has to be continued his suit only on the basis of pleading of the plaintiff number 1.
Correct. Now, my lord, what happens? Just go before the Honorable Supreme Court. Next page. Honorable Supreme Court confirms the order.
Yes.
Here, my lord, what actually happens? Your lordship will turn to the next page, 53.
Yes.
This is where confusion begins to arise. Last paragraph can be seen. Heard the learned counsel for the petitioner and various the records. In our view, the ID court is correctly interpreted order 1 for entertaining the prayer of respondent number 1 for transposition of E6's co-plaintiff because their interest in the suit is common. So this is where the confusion begins to arise. Technically, to go back, the suit is for challenging the gift deed between plaintiff and me. E6 did not execute the gift deed.
Yes.
He comes as a in
No,
effect.
court said co-plaintiff because their interest is also in the suit were common. Ultimately, he is the beneficiary.
This is where it starts.
Yes.
The adoption deed is challenged in the means.
Yes.
So that's a matter in trial. This comes in as an interim observation.
Yes.
Now, my lord, until here, what happens? Plaintiff and P1 need a dispute. Plaintiff executed the gift. P6 did not execute the gift. He comes on record as a co-plaintiff in the nature of an attorney to conduct the litigation.
That's not that 10-2 says. Rule 10-2 is been transposed as an only attorney. Attorney, he will come as in a GPA holder. But
effectively, if his locus standi is to be called in person, that is a matter in trial. Suppose he has no locus standi to contest this.
no, you have rightly went up to Supreme Court because he cannot be under 10-2, Rule 2. Because once it is allowed under Rule 10-2, he is a plaintiff as independent.
He is now a plaintiff. Now I have no option but to deal with these two orders.
Yes.
I can go back on these two orders.
Yes.
Now what happens, Lord? Suppose he had been an original plaintiff. Let us just go back and let us forget about all of this nonsense.
Yes.
Suppose he was the original plaintiff. My written statement would have simply said, between you and me, there is no risk. Because if it is not executed by you,
Yes.
if it is executed by dependent number 1, you are an unnecessary plaintiff.
Yes. Yes. You just watch that. There is. Yes.
Yes. Look, again, the reason why I'm stressing on this is, what is the nature of his presence in the suit?
Now, what is that order which you are
Yes,
challenging?
Lord, I am coming to that.
Yes.
Now we come up here, it's a bit complicated.
Yes.
Now your lordships may go to page 18. So he comes on record.
Yes.
And now plaintiff number 1 passes away.
Yes.
This is the memo reporting the day. Page number 80.
80.
80.
Yes.
Counsel for the plaintiffs respectively submitted under
Yes.
plaintiff number 1 Nagaratnama passed away on. Already the legal heirs are on record. There is no need to bring any other legal representative on. This is a memo which comes to be right. Now, Lord, I want to dwell on this memo for a moment. Who are the legal heirs? Not mentioned. How they become the legal heirs to her? Not mentioned. Does it be constituted only by a reporting of this new? Plaintiff number 2 is the legal heir. This is the question.
Yes.
My submission is no. Simply reports are there and it simply randomly says plaintiff. Of course, the suit will continue for plaintiff number 2. I am not saying the suit can be dismissed.
For plaintiff number 1, legal heir has to be come on record. Who are that legal heirs? No, whether she has any issues.
She doesn't have any issues. She had no children. She contains plaintiff number 2 is her adoption. That adoption is challenged by me in the original suit. So it's a matter of trial. This memo only says they are already on record. Now, my lord, why does this become important? The reason it becomes important is we want to know whether plaintiff number 2 continues as the legal on the basis of this memo.
Yes.
Or there is no bringing of LR of plaintiff number 1.
Yes.
In which case plaintiff number 1 abates and plaintiff number 2 continue. Now, on an aside, what happens? Somebody else also files an application saying, I am her legal heir through a will, etc.
Yes.
And that comes to be rejected, page 81. There's an independent procedure. Just to explain to this honorable court. Then many people try to come on record to say, now now.
Yes.
Page number 81.
Yes.
That application comes to be rejected.
81 is that High Court order.
This is of the other person.
Yes.
Yeah, Mahesh. Some other person files an application saying, I have a will. I am the legal legatee in respect of Nagaratnama. He files an application, trial is conducted, rejected, comes before the Honorable Court. in page number 81 and operator portion in page number 86.
Yes.
This honorable court says, please don't file your independent. The question in relation to whether or not Nagatnama's estate or Nagatnama's LR is substituted or not,
Yes.
still remains open. So we file an application at page 1.
Yes.
We be pleased to discuss having updated not in there, of course, has to be in respect of plaintiff number 1 only.
Yes.
Of course, it's a larger player. It comes to be objective. Thereafter, the impugned order is passed. That is what it starts.
Yes.
If the impugned order starts at page 150. How does the child court deal with it?
Yes.
May I begin at page 160? Paragraph number 9. Paragraph number 9 says exactly what we said about the transposition.
Yes.
Paragraph number 10 of the Honorable Supreme Court. Paragraph number 11 again. Further to be noted here that the adopted son of the deceased plaintiff, who the transpose as plaintiff number 2, is now become the legal heir. As adopted son, and he was arraigned as plaintiff number 2 even during the lifetime of P1. In such capacity as such, learning counsel for second plaintiff is a right in contending that no application is necessary to bring on the LR of deceased plaintiff number 1 when he is already on record pursuant to the order of the Honorable High Court, stated supra, which came to be confirmed by the Honorable Apex Court, cited supra, and the right to sue survives on the surviving plaintiff number 2 against dependents herein in the matter of suit relation respecting supra. This is a predetermination of is you happen to. That is what is challenged is on. When the question in relation to adoption is still to be decided in trial,
Yes.
this, my lord, could not have been done. This is. I am not saying the suit has to be. I'm never going to say that.
No, but your prior is that abate entire suit is wrong.
Entire suit really, but it has to be restricted to plaintiff number 1 only.
Yes.
That is the limited thing. Now, why is this necessary? Is because you do not know whether there is an automatic assumption.
That this is nothing but a prejudging that issue.
Correct. That is all my thing.
Yes.
If they want to let them keep it open for final adjudication before the trial, or prejudging the issue by saying he's already an adopted son, and treating him as a legal representative on the basis of a very superficial memo. Because the memo does not say how to be. If the memo had said a lot, which would have put me also on a better.
No, you have filed application under which provision?
Under 22 rule 5.
Where is your application?
Page 150. Is at 155.
Yes, I got it.
And in
No,
order
22.
at page.
No, order 22, rule 5.
Now, the honorable the trial court does not say who's her legal.
Yes.
It is assumed through this paragraph.
No, wait.
Yes.
We'll see that 22, rule 5. It will, I think, Rule 6.
Raised to 6, I think. 6 or 9, my lord, my memory is.
Notwithstanding anything contained for rules where their cause of action arises not, there shall be an abatement by reason of death of either of the parties within conclusion hearing so and so case will proceed. It will insolvency bar 6.
Maybe it raised to 5.
Yes.
Because of mentioning. When substitution is only limited to this.
Yes.
One, it results in a pre-adjudication of a matter which is in dispute. Point number 1. Point number 2, that memo which is filed by them, which I taken this on the 14th, does not state how they become the legal entity. And they should have done that to put me also in a position to say.
Yes.
Now, suppose they had said for a moment, he becomes the legal entity through a adoption. I would have objected to it accordingly. Yes. Now, he's not putting me on notice as to this is how it comes up. The memo is defective. And till now,
Yes.
there is no order as to substitutes.
Yes.
It results technically in an automatic abatement, even without the application. Filing of the application is resulting in this. We have to read it.
No, that you yourself has invited that.
It appears so.
Otherwise, that it is amended again at the plaintiff number 1.
It appears so.
Yes.
But now what the problem? It appears so. In fact, yes, I will have to. But what happens, pre-adjudication?
No, that now your application is rejected. What is the consequence?
What is the consequence?
Only that finding which is said that he is an adopted son.
Comes in.
That will say that without influencing this order, let them decide finally in accordance with.
That's all.
Now, Nagaram, only a faster data.
No, your memo.
Yes. I will one that there's that checker history. There's one strip chart we cannot go.
Yes.
That different number. Above it, line tip is in the paper. Line copy. You know the first different.
Yes.
So also. And again, the fifth dependent is Srimati Shamala. She is in USA.
Yes.
And the sixth dependent is H.N. Venkatachala.
Yes.
Where can you take the prayer? Because they did not supply only copy I have.
Yes.
I paid number 12.
Yes.
Wherefore the plaintiff motion declared that the sample court will please to pass judgment and decree to declare the instrument of gift date 16/3/2006 bearing the so and so registered before sub-register Karnataka in the name of dependent one Nirmala, that's the first dependent, is null and void, and same is obtained by misrepresentation, and same is invalid in law and not lawful document. Consequently, declare that the plaintiff is observed owner of the suitable property. First declare mandatory direct independent to sub-register to cancel the instrument of gift deed dated so and so original entries in the name of plaintiff in the relevant property registry in respect of suitable property. The suitable property mechanical technology, all entries and parcel of the property bearing BDS site number 40, 41 of Corporation 49 presently comes under jurisdiction of Ward 19 of Royal Palace Archit. Also Sadashiv Nagar, Bangalore. But this is now plaintiff is none other than the wife of late Agriculture Minister G. Narayanagowda. They have no issues. They have adopted this 6 people in Venkatachala. Adoption is in the year 1974. This is the 24/1974.
No, that you file a memo stating that plaintiff is an adopted son. He may be treated as an LR of that. Then court will decide on that point.
Earlier also on the bill, what they have set up bill.
See, now it is in a dispute that whether he is an adopted son or not. See, if that.
But if there is any challenge on the adoption, then what will?
No, that, see, you memo should be very clear that plaintiff number 2, by adoption, he is become a son. Therefore, he is in a legal representative. He may be treated as an. Now, no, it's very simple. See, you both has complicated this matter to went to Supreme Court and all. See, now the suit is only plaintiff wants to cancel that gift deed. It is given to the defendant.
Yes.
Now, by filing an application, one advantage you got it, your suit will not become abated because now that second plaintiff is there, he can continue the suit. But whether he is continuing on behalf of the plaintiff, that has to be decided. He can be continued as a plaintiff, but he cannot continue as an adopted son. The issue has to be decided.
The first defendant, she has not made an application. Her son has made an application. There's the first defendant son, not the first defendant. There's the first defendant son has made this application.
What application?
He want to be a legal heir of Nagaratnam.
Application reject ಆಯ್ತಲ್ಲ ಅದೆಲ್ಲ ರಿಜೆಕ್ಟ್ ಆಯ್ತು.
ಈಗ ಅದೇ ಕ್ಲೈಂಟ್ ಅಲ್ಲಿ how it comes and it has got the dependent number 6 client paragraph 5.
Yes. Paragraph 5.
Because 6 H.L. Venkatachala is the adopted son. See, in a client, adopted son of the plaintiff is arrayed as dependent. Since the family arrangement in the matter of distribution of properties and settlement deeds made amongst plaintiff, dependent number 1 and dependent number 5, and dependent number 6 are within the personal knowledge of the family members, more particularly well acquainted with the family affairs. In order to place true and correct fact, dependent number 6 is made formal dependent. This plaintiff reserves the right to transpose the dependent number 6 as co-plaintiff in the course of the proceedings by making necessary application.
Yes.
Already plaintiff herself in the presenting the client, she declared that he is the adopted son. At the time of filing of the suit,
see, you file a memo. Now that suit in respect of first plaintiff is abated by operation of law, it is abated.
She passed away because immediately after deposing.
No, Mr. See, it is abated. Now you have to file you are that one of the plaintiff, you have to file a memo or application. If there is LRs, you have to file an application under that order 22 to bring LR. If there is already on record, you have to file a memo saying that these are all the LRs who are already on record, they may be treated. Then he will file an objection. How can you become an adopted son and all? Nothing is there. Your memo, see, you have not mentioned who is that person who is already. That means to say even dependent is also LR.
No, their argument is like that.
You see that memo. Memo is not clear.
Well, on that memo, as well as now the impugned order, the challenge. May I kindly take the sample court to the impugned order? It in elaborate way and well-reasoned order. May I kindly take the
no, impugned order. Court, see, impugned order court said that plaintiff number 2 is an adopted son.
Earlier, they have set up one bill that is first dependent. On the bill also there is a detailed inquiry and.
No, see, it is also their written statement. They have denied that he is not an adopted son.
Well, there is no specific pleadings to that extent.
We'll see. If there is a denial, without trial, court can hold that in the interlocutory application. He is an adopted son. What left for him to prove now?
No, because court on its own has not observed, our court is not as passed the order.
Yes.
Court, right, because client and statement of client is a fact, it is a foundation.
No, that has to be proved.
Where client, because if I say, let us take this situation, if this Venkatachala has come before the court, and if he has filed independent suit, and if he says that I am adopted son, and I am so and so and so, then they have the right to deny. Now, the plaintiff Nagaratnam, the mother, she herself has present client in an unequivocal term. In the client, what is stated in the client is admitted. She herself has stated that he is my adopted son.
No, but why person telling that his adopted son will not become a adopted son. There is a procedure and law.
It is everything.
You cannot adopt the person who become a major. There are, and adoption is also by the consent of that other this thing. Adoption is separate law there. That cannot be.
That in the strict proof of that law only in 1974.
Yes.
Now all these things have started only after death of Nagaratma. They know very well, and there was a family arrangement also. The properties which are also divided among these two daughters, they enjoyed it. Now on the property which was now as a legal heir is successful to this dwelling house. Now this problem and this dispute they have raised. This is 1974 adoption date. Now this suit is presented in the year 2000. This is 2008.
Yes.
2008. Period of 74 to 2008, almost about 30 years. Not even little finger they have raised, and they know very well about this adoption and a registered adoption and the properties which were laid.
I think you prove Madi. If you prove that,
But now
that first you have to prove you are an adopted son.
Definitely.
Second is that then as an adopted son, ultimately rights comes to you if you prove that gift is illegal or misrepresenting by that, then automatically your property.
That the gift now one more bill also they have set up. And the bill also there is a detailed order passed in the 22-3. By the very same.
ಅದು ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರಲ್ಲ ಬಿಡಿ ಎಲ್ಲರೂ
Reject ಆಗಿದೆ. ಅದಾಗಿದೆ. ಅದರಲ್ಲೇ ಕನ್ಸಿಡರ್ ಎಲ್ಲ ಡೀಟೇಲ್ ಎವಿಡೆನ್ಸ್ ಕೊಟ್ಟು ಕನ್ಸಿಡರ್ ಮಾಡೋದು. ಅದಾದ್ಮೇಲೆ ಅದು ಹೋಗ್ತಾ ಇದ್ದಕ್ಕೆ ಈ ಒಂದು ಗಿಫ್ಟ್ ಇಟ್ ಸೆಟಪ್ ಮಾಡೋದು. ಅವ್ರ ಮಗನ ಕೈಲಿ ಈಗ ಸಪೋಸ್ if she has set up that gift date first time, things would have been different. Now she set up her own son to file this application. Son has nothing to do with this property or nothing to do with the family also. Because there are different families, but of course, during their childhood, giving education.
Till earth is there, in all property in Bangalore will be the litigation.
ಇದು ಬರೀ ಬ್ಯಾಂಗ್ಳೂರ್ ಅಲ್ಲ, ಅಗ್ರಿಕಲ್ಚರ್ ಪ್ರಾಪರ್ಟೀಸ್ ಇದು ಊರಲ್ಲಿ ಅದೆಲ್ಲ ಈಸ್ ಎಂಜಾಯಿಂಗ್ ರೈಟ್ ಫ್ರಮ್ 1974 after adoption. Now it is the
that adopted person who is claiming the plaintiff number 2 is a relative or
they have no issue. They adopted in 1974. These two
no, this dependents are how they are related.
It's the brother, his own brother and their own sister.
ಯಾರ್ದು ಬ್ರದರ್
ಈ ವೆಂಕಟಾಚಲ ಸೆಕೆಂಡ್ ಪ್ಲೇಂಟಿಫ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದ್ದಾರೆ. ಅವರ ಸಿಸ್ಟರ್ಸ್ ಅವರು ಡಿಪೆಂಡ್ ನಂಬರ್ 1 and ಡಿಪೆಂಡ್ ನಂಬರ್ 5. Depend on 5 after giving good education.
One of these brother has been taken as adoption. That is what they are.
One daughter she is well settled in America. Other daughter she is also well settled. Now on this property.
No, this they are that how they are related to Nagaratnama. Nagaratnama yaru?
Nagaratnama is wife of Narayana.
Narayana Gowda. Nagaratnama has given a gift deed.
Alla ibru. We have a scene which is not relevant for any one of us. Even number 6 was well established, 5 was well established.
No, gift ಕೊಟ್ಟಿದ್ದಾರೋ ನಾಗರತ್ನಮ್ಮಗೂ ಮತ್ತೆ ನಿರ್ಮಲಾ ಅವ್ರಿಗೂ ಏನ್ ಸಂಬಂಧ?
ಸಂಬಂಧ ಇಲ್ಲ, ಇವ್ನ ಫಾಸ್ಟರ್ ಟ್ಯಾಕ್ಟರ್ಸ್ ಅಂತ ಇಟ್ಕೊಂಡಿದ್ರು ಅಷ್ಟೇ. ಇವ್ರು ಓದ್ಲಿಕ್ಕೆ ಊರಿಂದ ಕರ್ಕೊಂಡು ಬಂದು ಇಲ್ಲಿ ಓದ್ಕೊಂಡು ಅವ್ರಿಗೆ ಒಂದು ಎಜುಕೇಶನ್ ಕೊಟ್ಟರು ಅಲ್ವರೆಗೂ. ಅದಕ್ಕೆ ಫಾಸ್ಟರ್ ಟ್ಯಾಕ್ಟರ್ ಇವ್ರ ಅದಕ್ಕೆ ಒಬ್ಬ ಗಂಡು ಮಗನ್ನ ಅವ್ರು ಅಡಾಪ್ಟ್ ಮಾಡ್ತಾರೆ. ಅಡಾಪ್ಷನ್ ಈಸ್ ಬೈ ರಿಜಿಸ್ಟರ್ಡ್ ಡೀಡ್ and also in all in strict compliance with the adoption law.
No, mister, you could have filed a memo. Along with that, there is an adoption deed. He is not only a plaintiff, he is also an LR of that plaintiff number 1 ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಹಾಕಿ ಪ್ರೂವ್ ಮಾಡಿದ್ರೆ everything is over.
Now we cannot only to that memo, we cannot restrict technically because
ಅಲ್ಲ ಮೆಮೊದಲ್ಲಿ ಏನು ಇಲ್ಲ. whom you want to go.
Now on this application the Ahmed Talco, now an order is passed. May I kindly take in its entirety the order, then only my lord can understand. Yes, it is assessed the way in which the Ahmed Talco has passed the order and that order stands close. Now the order is on IA number IA dated 43 November under 22 rule 5.
Yes.
22 rule 5 determination of question as to legal representative.
Yes.
Where a question arises.
ಇದು 5 ಯಾವಾಗ ಬರುತ್ತೆ ಗೊತ್ತಾ? ನಿಮ್ ಮೆಮೊ ಮೇಲೆ ಡಿಟರ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಈ 5 ಒಳಗಡೆ ನೀವು ಲೀಗಲ್ ಏರ್ ಅಲ್ಲ ಹೌದು ಅಂತ ಇವ್ರು ಹಾಕ್ಬೇಕಾಗಿರೋದು 6. They have mentioned wrong provision ಅಷ್ಟೇ.
Whether any person is or not legal representative of a deceased plaintiff or deceased dependent, such question
meant by the court. Now, let us
ಅದು
take-
ನಿಮ್ಮ ಮೆಮೋದ ಮೇಲೆ ಕೋರ್ಟ್ ಈ ಕೆಲಸ ಮಾಡ್ಬೇಕು. ಅಂಡರ್ ರೂಲ್ 5 ಒಳಗಡೆ ಇವನು ಎಲ್ಲಾರು ಹೌದೋ ಅಲ್ವೋ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅದಕ್ಕೆ ನೀವು ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕು ಇವನು ಅಂತ. ಅವಾಗ ಕೋರ್ಟ್ ಇವ್ರು ಅಂತ ಗೊತ್ತಾಗುತ್ತೆ. ದೇ ಆರ್ ಆಲ್ರೆಡಿ ಆನ್ ರೆಕಾರ್ಡ್ ಅಂದ್ರೆ ಯಾರು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಹೇಳ್ಬೇಕಲ್ಲ. Yes.
Assessment.
Yes.
Correct. The first defendant shown in our update that Srimati Nagaratnama in the suit has sought to set aside the gift deed dated 16/3/2006
Yes.
executed by her in favor of the defendant number 1,
Yes.
whereby the suit scheduled property was gifted by her in entirety to her, and during pendency of the suit, the defendant number 6 was transferred to the second plaintiff immediately after demise of the first plaintiff, Srimati Nagaratnama. Advocate for second plaintiff filed a memo to the effect that since the legal representatives were on record, there was no need to file application. It has always been the case of the second plaintiff that he was the agent of first plaintiff in WP so and so on 3/1/2001. There was a specific finding that in relation to the will, there has been no judicial findings and there has only been direction to the trial court to the fresh suit. Accordingly, Mr. M.R. Mahesh filed a fresh suit in OS. He already filed a suit. OS 2012/14. Hitherto, no person has been substituted as legal representative to the estate of deceased plaintiff number 1. In the absence of same, there is an automatic abatement of our estate. It does not devolve any party to the suit, and the suit therefore has to be dismissed. On the contrary, second plaintiff submitted objections contending that he is adopted son of plaintiff number 1. His adoption was under the registered adoption date dated 24/1974, and he was taken in adoption by the first plaintiff and her husband. And ever since, as their son, discharging all the obligations, duties which is known to the whole world. Mr. M.R. Mahesh is none other than the son of the first defendant, creating an alleged document of will, which has been considered in detail, and court has already rendered decision. And the will, court has already rendered decision. Now, to circumvent with this situation, first defendant and her son are making dubious acts to deviate the whole issue and to conclude the entire issue. In memo dated 5/1/2011, it is clearly stated in unequivocal terms that second plaintiff is already on record and as a legal heir as adopted son representing the estate of the deceased first plaintiff, and also by order of the court. He was transposed from defendant number 6 to co-plaintiff. He can independently put forth a case and could assist the court for effectual adjudication of the dispute. And he being the adopted son, he is competent to represent the estate of the deceased plaintiff as her legal heir under section 22 under order 22 of CPC. Therefore, IA is left to dismiss. With me of the above contention, these are the two issues. Question. Point number 1. One Srimati Nagaratnama, wife of G. Narayana Gowda, instituted suit against defendant number 1 and 6 to declare the instrument of gift deed dated 16/3/2006 registered in the office of Sub-Registrar Gandhinagara in the name of defendant number Srimati Nirmala is null and void. Same is obtained by misrepresentation and same is invalid in law and not lawful document. Consequently, to declare that she is the absolute owner of the suit scheduled property. Further, he has sought for consequential relief, which in fact is not necessary to mention here for so and so. In the suit, she had pleaded that she is residing with her son H.N. Venkatachala, defendant number 6, in the village Okalagere, Srinivasapura Taluk, Kolar district. She is the wife of late Narayana Gowda, former Minister for Agriculture in the erstwhile state of Mysore. She has pleaded that the 6th defendant H.N. Venkatachala is an adopted son, and she made him as defendant number 6 a reserve right to transpose him as a co-plaintiff. She has pleaded that first defendant and 5th defendant are a foster daughter. She has also pleaded that under deed of adoption dated 20th April 1974, 6th defendant H.N. Venkatachala, son of K.V. Nanjundaya, was adopted by herself and her late husband. This fact, in fact, is not disputed by any of the parties to the suit. If we examine written statement of 5th defendant, as stated that she and defendant 1 are foster daughters of G. Narayana Gowda and Srimati Nagaratnama. She has submitted that their brother H.N. Venkatachala was adopted to late Narayana Gowda and his wife Srimati Nagaratnama under a deed of adoption dated 24/1974. Most important fact to be noted here that the Nagaratnama deceased first plaintiff filed a requisition so and so agreed by the order of I number 10
filed under R1 Rule 10(2) of CPC to transpose dependent number 6 to co-plaintiff dated 29/8/2009, which came to be allowed by Honorable High Court on 2nd September 2010, wherein dependent number 6 stands transposed as plaintiff number 2, and the written statement filed by dependent number 6 stands struck off. The additional plaintiff shall proceed with the case of the original plaintiff, and he will not have any right to plead his own case, since he had already been formally impleaded as a party in the suit. Thus, Honorable Court held that there would not be any additional pleadings by the transposed plaintiff. Further, to take judicial notice of the order in special leave petition appeal so of the Honorable Apex Court dated 19/10/2009, it was held in our view that the High Court has correctly interpreted R1 Rule 10 CPC for entertaining the prayer of respondent number 1 for transposition of the dependent number 6 as co-plaintiff, because their interest in the suit were common, and the respondent number 1 had already reserved a right to make a prayer for the impleading dependent number 6 as a co-plaintiff. He is sufficient to hold that right to sue, and the cause pleaded by the deceased plaintiff number 1 survives. In other words, to say that the suit survives even after death of Srimati Nagaratnamma. First plaintiff as such contention that suit does not survive would not be of no legal substance. Further to be noted here that adopted son of deceased plaintiff number 1 not only transposed as plaintiff number 2 is now become legal heir as adopted son, and he was arrayed as plaintiff number 2 even during the lifetime of plaintiff number 1. In such capacity, as such, learned counsel for second plaintiff is right in contending that no application is necessary to bring on record the legal representative of deceased first plaintiff when he is already on record pursuant to the order of the Honorable High Court stated supra, which came to be confirmed by Honorable Apex Court. Cited supra as right to sue survives to the surviving plaintiff number 2 against dependents herein. In the manner suit relief in respect of suit property. The most important fact to be noted here that the deceased plaintiff in her client itself has stated H.N. Venkatachala, 6th dependent is her adopted son, and first and 5th dependents are her foster daughters. He is further fortified from the defense set up by 5th dependent, who is none other than full-blood sister of first dependent. Further to make mention here that son of the first dependent, Mr. Mahesh, has instituted OS 2012 of 2014, and he filed such a suit pursuant to the order dated 3/1/2014 of the High Court in WP zone. So it is submitted that the said suit is also allocated to this court for disposal in accordance with law. In the above such circumstances, contention of learned counsel for first amendment that the present suit does not survive in the absence of substituting legal representative to succeed to the estate of deceased plaintiff number 1, as its effect would be an automatic abatement of her estate, and it does not devolve upon any party to the suit would not be acceptable in view of the orders of the Honorable High Court and Honorable Apex Court cited supra. Since the right to survive against dependent in respect of the suit property, as the Honorable Apex Court held that their interest in the suit were common, and the deceased plaintiff in a
Mr. Counsel, ultimately court said suit will not abate. Yes, because he is there. Only thing is that only I can say that decide that suit without influencing any observation made in this IA.
And
No, that is what that.
And second,
Without influencing.
no, second thing is, if he is really a legal heir succeed to estate, he has got his own independent suit because after passing of the order
Ultimately,
by the Sovereign Court.
he is not saying that. He may be prior is wrong. Ultimately, court said suit will not abate because he has been impleaded as a co-plaintiff.
Deputy to suit the
Suit
plaintiff.
up. No. When court by answering that, there is some paragraph saying that he is adopted son. When deciding that suit without influencing, decide it's in accordance with law. That's all.
And
That is even I need not say when court deciding that matter on merit, they need not relied on that what is on that interlocutory application.
Yes.
But I will make it that when he has before this court, will say that without that they can decide. That's all.
And court on its own, it did not say. Court said because taking the foundation, client in the client, she said
he is my adopted son. Because if he on his own independently if he has come, then what my learned friend says is correct. It is the plaintiff herself said in the year 1974. Now their suit is of the year 2014.
Now you are the king. You are the only a plaintiff. You also prove that I am an adopted son and also shows that that gift deed is illegal. That's what that now decided by the court. Yes.
Already on the will also elaborate evidence.
You take that advantage.
The fate of gift also same thing.
Yes.
2015, 2023 in CRP it has logged here.
Why that? See, this is a simple.
Simple man.
One of them has to be say before the court saying that let the suit decide without influencing on this findings. Any observation made by this court in that interlocutory application need not be considered at the time of final hearing. That is the law.
That's the law. And
But that observation you have over court ಮಾಡಿರೋರು ಇಷ್ಟೊತ್ತಿಗೆ ತೀರ್ಮಾನ ಆಗೋಗಿರೋದು.
Without saying it was. ನಾನು ತಮ್ಮಲ್ಲಿ ಮನವಿ ಮಾಡೋದಂದ್ರೆ ಡಿಸ್ಪೋಸ್ ಮಾಡಿಬಿಟ್ಟು ನಾನು ಒಂದು ಟೈಮ್ ಕೊಟ್ಬಿಟ್ರೆ so the day to day we can conduct and we can conduct.
What is that position now?
Position is only now as it is the issues ಆದಂಗಿದೆ evidence ಗೆ ಹೋಗ್ಬೇಕು.
Yes, we'll fix some date. Yes. Yes, this petition is filed by dependent.
Dependent ಇಲ್ಲ ಏಕೆ
Allah. No. Dependent number. Dependent number 1. Yes, this petition is filed by dependent number 1. Challenging this revision petition is filed by dependent number 1 under section 115 of CPC, challenging order dated 31st July 2015, passed by 9th Additional City Civil and Session Judge Bangalore in OS number 2060 of 2008 and IA filed under Article 22, Rule 5, read with 151 of CPC, whereby application is rejected. Plaintiff, for the convenience, parties are referred to the ranking as per the trial court. Plaintiff has filed in a suit for declaration declaring that gift deed dated 16/3/2006 executed by Srimati Nagaratnamma in favor of defendant number 1 is null and void and other consequential relief. During the pendency of suit, Nagaratnamma died. The plaintiff number 2 has been arrived as a co-plaintiff, has filed in a memo, treated him as a legal representative of deceased Nagaratnamma. Advocate for the plaintiff. Yes. Advocate for the plaintiff has filed in a memo. Yes. Has filed in a memo stating that LRs of deceased Nagaratnamma is already on record. They may be treated as LRs. The defendant number 1 has filed application under Order 22, Rule 5. Stating the Rule 5 prayed for declaring that suit has become abate due to the death of Srimati Nagaratnamma. Trial court, by impugn order, has said that since plaintiff number 2 is a party in the suit will not abate by whole. By considering that application, the court has made an observation that plaintiff number 2 is the adopted son of plaintiff number 1, Nagaratnamma. Being agreed by the same, the defendant number 1 has filed this revision petition before this court. So and so learned counsel appearing for defendant number 1 has contended that due to the death of Nagaratnamma, suit in respect of Nagaratnamma is abate. No LRs has been brought on record. While considering that application filed by the defendant number 1, the trial court has given a finding that defendant number 2 is the adopted son of plaintiff number 2 is the adopted son of deceased Nagaratnamma. This finding is prejudging the issue since defendant has disputed the same. Before conducting the trial court has adjudicated the rights of the plaintiff number 2. So and so learned counsel appearing for the plaintiff number 2 has contended that it is very clear from the pleading that plaintiff number 2 is the adopted son of deceased Nagaratnamma. Even in the earlier proceedings, it has been concluded that plaintiff number 2 is the adopted son of Nagaratnamma. Be that as it may, dispute in respect of that adoptions and that gift deed is pending before the trial court. The order is only in respect of abatement of the suit. Only relief can be granted in this petition is trial court may be directed to dispose of the suit as expeditiously as possible without influencing any observation made in that impugn order. Accordingly, the civil revision petition is disposed of. The trial court is directed to decide that matter in accordance with law without influencing any observation made in that impugn order within 1 year from the date of receipt of a copy of this. Evidence ಇದರಲ್ಲಿ ಒಂದು ಎವಿಡೆನ್ಸ್ ಆದ್ರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟಿಗೆ ಹೋಗ್ತಾರೆ. ಇದೆಲ್ಲ ಬೆಂಗಳೂರಲ್ಲಿ ಪ್ರಾಪರ್ಟಿ ಎಲ್ಲಿ ಇರ್ಬೇಕಿದು? Where is that property? It is what is the value of the property? Then nobody will allow to dispose it in 1 year. Yes. Anyhow, for your satisfaction, I have fixed 1 year. Yes. Within 1 year from the date of receipt of the copy of it. Yes. Yes.
ವೆರಿಫೈ ಮಾಡಕ್ಕೆ ಡಿಸ್ಪೋಸ್ ಆಗುತ್ತೆ. ಏನಂತ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ?
It is verified from the trial court records. The suit itself is ಯಾವ dispose ಆಗಿದೆ?
ಇನ್ನೊಂದು 11/3/2015. 11/3/2015 ಈ ಆರ್ಡರ್ dispose ಆಗಿದೆ. Filed by the petitioner in Pecuniary hereby dismissed. The suit is filed forthwith within 1 month from the date of to file the suit as an ingredient of property suit. Petition filed by the petitioner is dismissed. Now, this property suit is dismissed ಆಗಿದೆ. ಆಮೇಲೆ
Now that trial court became secondary. Yes. ಏನು ಯಾರು appellant 6 times. None appear for the appellant. Even when the matter is called in morning session, and even in the afternoon session. The last chance, read this matter next week.
Number 57, so the appellant, Ananta Krishnamurthy. Number 57.
Here for vacating and admitted. What is this, Mr. Cooper?
For partition. Doing the response number 2. The trial court initially had granted the interim order in the nature of not to alienate the suited property. Has been vacated by the trial court after the after hearing on both the parties.
Application and the plaintiff is hereby dismissed. Application for the defendant here by not ex parte temporary matter. Yes, schedule. How many scheduled properties are there?
There are 2 scheduled properties there.
No, yes, scheduled properties they are there.
Scheduled properties,
Why?
the scheduled property is the property of the response number 2 with the grandfather of the plaintiff.
Is there any interim order here?
The December can granted the agreement.
That will continue. There. Two.
2016.
For the respondent number 2 submit that he has received the copy today. Appellant would submit that response may be.
Serial number 57. Here for the respondent, Mala.
Yes, yes.
Okay, weeks time, Mala.
Considering the same, both the parties are required to maintain status. Now, Mr. Counsel.
Yes, ma'am.
From 2016, there is a status quo order is there.
Yes,
I will
ma'am.
direct the trial court to dispose of the suit.
Monday, you will also fix it on Monday, call the party and direct. Monday, let you will
No,
also.
why party require, Mister?
ಕೇಳ್ಬಿಡ್ತೀವಿ ಈಗ ಒಂದು ಮಾತು ಹೇಳ್ಬಿಡ್ತೀವಿ ಸುಮ್ಮನೆ
ಅವ್ರು ಹೇಳೋದಲ್ಲ, you pass an order, court order. You need not. ಅಲ್ರಿ 15 ವರ್ಷ 8 ವರ್ಷದಿಂದ ಸ್ಟೇಟಸ್ ಕೋ ಇಲ್ಲೇ ಇದೆ. ನೀವು ಅವಾಗ ಹೇಳಿದ್ರೆ ಎಷ್ಟೊತ್ತಿಗೆ ಸೂಟ್ ಡಿಸ್ಪೋಸ್ ಆಗಿ. Yes.
ನಾಳೆ
No, Mister, I will pass an order on merit. What you want to say from the client, Mister? What he will say, tell me that. Any instruction you needed? Yes. See what from last 8 years, status quo is in there. Let the trial court dispose of the suit. What is the stage in the suit?
I have no idea. I have no idea. I have no idea.
Cross examination. Let it finish within 1 year. ಇಲ್ಲ ಅಂದ್ರೆ ಇನ್ 3 ವರ್ಷ ಸ್ಟೇಟಸ್ ಇರ್ತದೆ. ವಾಟ್ ಇಸ್ ದ ಯೂಸ್? ಸಿ ವೆದರ್ ಇಟ್ ವಿಲ್ ಗಿವ್ ಎನಿ ಬೆನಿಫಿಟ್ ಟು ಯುವರ್ ಕ್ಲೈಂಟ್. ಟೆಲ್ ಮಿ 8 years ಸ್ಟೇಟಸ್ ಇಸ್ ದೇರ್. You could have mentioned in that immediately after 6 months. ಆಯ್ತು ಸ್ವಾಮಿ, ಇಲ್ಲ ವೆಕೇಟಿಂಗ್ ಮಾಡಿಸ್ಬೇಕು, ಇಲ್ಲ ಅಂತ ಅಂದ್ರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಮಾಡೋದಕ್ಕೆ ಮಾಡಬೇಕು. 8 ವರ್ಷ ಸುಮ್ಮನೆ ಸ್ಟೇಟಸ್ ಕಟ್ಕೊಂಡು ಕೂತ್ಕೊಂಡಿದ್ದೀರಾ. ಆಲ್ ಮ್ಯಾಟರ್ಸ್ ಇಸ್ ಲೈಕ್ ದಟ್ ಒನ್ಲಿ. That means that nobody is protecting the interest of the parties, Mister. Yes. Then this appeal is filed by plaintiff challenging order dated 19th February 2016, passed by th Additional City Civil and Session Judge, Bangalore, in OS number 8757 of 2012, whereby application filed by the plaintiff under Order 39, Rule 1 and 2 is Dismissed. For the convenience, parties are referred to the ranking as per the trial court. Plaintiff has filed a suit for partition and separate possession. The trial court has granted an ex parte injunction order. After appearance of the defendant, they have filed IA number 3 under Order 39 Rule 4 for vacating that ex parte interim order. The trial court, considering that IA number 1 filed by the plaintiff under Order 39 Rule 1 and 2, and application filed by the defendant under Order 39 Rule 4, and after hearing the parties by impugn order, IA filed by the plaintiff is rejected. IA filed by defendant has been allowed by vacating the ex parte injunction order. Being agreed by the same, the plaintiff has filed this appeal before this court. This court on 22/4/2016 has granted an interim order. Both the parties are directed to maintain status quo regarding descheduled property. Na? Scheduled parties to direct to maintain status quo in respect of scheduled property. Is it, where is your application? Is it for only one or entire property? Yes, parties are maintained status quo in respect of food scheduled property. That this order is operating till today. Now that learned counsel for the plaintiff has submitted that suit is set down for evidence of the parties. Cross examination, set down for cross examination of plaintiff. Under these circumstances, the only relief can be granted that trial court may be directed to dispose of the suit as expeditiously as possible. And that the interim order granted by this court will be continued till the disposal of the suit. Accordingly, the appeal is allowed in part. Order dated 19th February 2016 is modified to that effect that parties are directed to maintain. Accordingly, the appeal is disposed of. The trial court is directed to dispose of the suit as expeditiously as possible, not later than 1 year from the date of receipt of a copy of this order. The parties are directed to be the interim order. The parties are directed to be maintained status quo till the disposal of the suit. Yes, Yes, Mr. Nagaraj. Yes. Yes. 36,800 per acre. 2,060. Yes. ಕೊಡಿ ಆರ್ಡರ್. ಎಲ್ಲಿದೆ ಇಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ?
sir.
No, where is that order of this court, mister? You don't have an order, that enhancement order.
Similar matter. Same reference. It is produced along with my instant document.
ಅದನ್ನ ಕೇಳಿ, ಅದನ್ನ ಕೊಡಿ ಅಂತ ನನ್ನ.
There is filed, my application is filed on 28/9/2020. Then this honorable player to reference in the same village. It was acquired in 9/12/95.
9/12?
95.
7/12/95.
Sorry, 7/12/95.
Compensation
is awarded 7,26,000.
7,26,000.
26,000.
This is by reference code.
By the reference code.
ಇದರಲ್ಲಿ ಇವ್ರು ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರು? ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಆಫೀಸರ್ ಎಷ್ಟು ಅವಾರ್ಡ್ ಮಾಡಿದ್ರು? 10,000. 10,000 ಅನ್ನ 60. 10,000 ಇದ್ದಿದ್ದನ್ನ 7 lakhs ಮಾಡಿದ್ದಾರೆ.
Now I am claiming the same amount from appreciation of 10% from the date of disqualification to over 2003 notification.
ಎಲ್ಲಿದೆ ಜಡ್ಜ್ಮೆಂಟ್ ಅದಕ್ಕೆ?
This year, 746.
Yes. Yes.
We did not find any reason to ignore the changes. These to take respondents in support of their case. As mentioned, the same is dated 1971. This in respect of 11 villas and 10 viswas. Land situated in the village of Rosaronpura. As per the same deed, the fees for the price of the villa of the land involved, there will be about 2,000. The pressure of the land in possession as well as the land covered under the same deed is 1971. Approximately having the evidence substituted. Beneficiary and petition laid upon the same deed 1971 as the core basis to uphold the prayer of the evidence. From Joseph was necessary and the compilation of land acquired. One has to pursue from the viewpoint of the prudent citizen. Remit the matter to the reference court, having regard to the totality of the facts and circumstances of the matter. To consider the opinion that application may be relying upon the same deed 1970, particularly when there is no other reliable material. Since the land and the sales have been retained 1971 was valued at the sum of 2,000 rupees per villa. But the land in question was acquired in the year 1973. The compensation can be determined by adding 15% of the value of the sale consideration. But the estimation is of the land day to day, not only 15% estimation is taken per year by this one.
No, this is an non-agriculture land. Non-agriculture land, therefore 15%. ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್ ಗೆ ವರ್ಷ 15% ಯಾರು ಕೊಡ್ತಾರೆ? ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್ ಗೆ ಯಾವ್ದಾರ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ಕೊಡಿ. ಯಾವ್ದ್ರಲ್ಲಿ? ಯಾವ ಬೇಸಿಸ್ ಮೇಲೆ ನಿಮ್ 10%? ಆಯ್ತ್ರಿ, ಎಷ್ಟು ಒಂದ್ ವರ್ಷಕ್ಕೆ 10% ಎಲ್ರಿ ಜಾಸ್ತಿ ಆಗುತ್ತೆ ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್? ಹಂಗಿದ್ರೆ ಹೇಳಿ, ನಮ್ದು ಲ್ಯಾಂಡ್ ಇದ್ದ ಕೊಡ್ತೀವಿ, ನೀವು 10% ಯಾರು? No, that you give me that for agriculture land there is a judgment. That is not that market value ne tagundu 10% increase kodbeku anta ellige. Totally landlord must be entitled to 8% flat increasing over the market. In the absence of evidence, you have to appreciate the value increasing from urban and sub-urban area 10 to 15%. Urban area dalli 10ರಿಂದ 15% ಅಂತ ಹೇಳ್ತಾರೆ. 10% ಕೊಡಿ.
Yes, I think this they are seeking parity with that. So
that has been acquired.
The
Same project.
Yes, yes. The release code
No, see. No, he is saying that this 7 lakhs ಅಂತಂದ್ರೆ ಒಂದು ಎಕರೆಗೆ ಎಷ್ಟು? ಒಂದು ಎಕರೆಗೆ 7 lakhs ಮಾಡಿರೋದು. No, that 7 lakhs has been fixed. 1 acre. Due to that, acquisition is in the year 1991. Hmm. 95 ಅಲ್ಲಿ 1 ಎಕರೆಗೆ 7 ಲಕ್ಷ ಇದ್ರೆ ನಿಮ್ದು ಯಾವಾಗ ಅಕ್ವೈರ್ ಆಗಿರೋದು? 2003 ಲಿ 7 ಲಕ್ಷನೇನಾ? ನೋ, ಅಪೀಲ್ ಯಾವಾಗ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡೋದು ಡೇಟ್ ಆಫ್ ದಟ್ ಅಕ್ವಿಸಿಷನ್. 2017 ವ್ಯಾಲ್ಯೂ ನೋಡೋದಲ್ಲ. They will value that date of that acquisition. Date of the acquisition 7 lakhs has been fixed. Date of the preliminary notification under 1995 ali court has come to the conclusion that this is a 7 lakhs. Now he is saying that for another 10 years, 11 years, another 5-6 years, 8 years ಗೆ ಇನ್ನೊಂದು ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಮಾಡ್ಕೊಡಿ ಅಂತ ಅವ್ರು ಕೇಳ್ತಾ ಇದ್ದಾರೆ. Give me that any judgment. Both of them has not giving any judgment. Agriculture land ಕೊಡ್ರಿ, ಎಷ್ಟು %? ಇದಾರೆ. No, the earlier court has expressed that we will give that 7 lakhs. Same thing, Mr. Nagaraj. ಎಲ್ಲಿದೆ ಕೊಡಿ ನನಗೆ ಜಡ್ಜ್ಮೆಂಟ್. ಇವೆಲ್ಲವೂ ಅರ್ಬನ್ ಲ್ಯಾಂಡ್.
Where last para is totally circumstances in our view, the landlord must be held entitled to 8% flat increase for the market value.
ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳ್ರಿ, ಅದೇನು ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್ ಇದ ಅಂತ?
Agriculture land.
ಎಲ್ಲಿ ತೋರ್ಸಿ ಒಳ್ಳೆ ಕಥೆ ಇತ್ತಲ್ಲ ಹೌದು ಅಂತ ನಂಗೆ ಹೇಳ್ಬಿಟ್ರೆ. It is Gurgaon only. Industrial flats.
Industrial.
ಮತ್ತೆ ಆಯ್ತ್ರಿ ಅದೆಲ್ಲ this is not applicable, Mr. Either I will give that 7 lakhs and odd or give a judgment. I will apply same this thing which is
insufficient and the market value.
yes. You show me that any agriculture land that 8% has to be announced. Any judgment on that point?
Actually, number 2736. So, what is the third petition of 103.34 acres, 183.3 acres, 458 acres in the village.
ಇದೆಲ್ಲ commercial by yard ಲೆಕ್ಕದ.
Agriculture land of 300 acres of commercial.
No, by yard they have calculated.
ಯಾವ 608 acres village, the lorry from the village developed for commercial, institutional, recreations and residential purpose. Recreation purpose, commercial purpose, some agriculture land, they have converted into commercial purpose.
Yes.
Here is the case, is the agriculture, this is also an agriculture land.
Yes.
8% was announced.
Where?
That is what para in respect of land acquired to the notification, June 1982, the High Court granted 30% increase for the time gap between 1986, 1982 and arrived at the compensation in para 3 last portion of the order.
Yes.
Before the para. The High Court granted 30% increase for the time gap between 1986, 1982 and arrived at a compensation of rupees 566 per square yard.
Yes.
Regarding the compensation payment for acquisition of land and the notification of 3rd July 85. High Court finalized the market value at 795 per square yard, granting increase of 12% per annum on a community basis on the compensation payable for the land and the notification dated 4 June 1990. 12%, at least 10% should be given. How do you acquire yourself after the acquisition? It will become a commercial. It is not a public area. Everything is public purpose. Not non-commercial land, agriculture land. We are losing our revenue by losing of this land. That is important to consider. Also, para 13 में 20. Increase in lands prices depends on 4 factors. Situation of land, nature of the development.
Yes. 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 Page number? Page number?
26.
Really the page 26. Page number ಇದೆಲ್ಲಿದೆ 26 ಇಲ್ಲ ಆಯ್ತು ಹೇಳಿ Yes.
In most of the cases involved in the petition of the market value of the land. Needless to say that the previous awards in respect of similarly situated lands market value the evidence by any direct evidence on the same point, the court can take inputs to other factors. This is fixed was past in the same village and or neighboring villages, the reference to and also and is similar to any absolute city, now Mr. Bednar, now this is 89, I guess so I think both are situated in the same village, both are equal to the same.
Oh, it's same village. Property which has been acquired 20 years, 7 lakhs has been granted. After 20 years, adjacent land. That is what to be determined by the court has said, madam. What is this said that? See what the judgment says. Similarly, adjacent properties on 1 or 2 years, this or that side, any properties are sold, that has to be compared. That is what said. If there is no such document is available, if adjacent lands, there is a compensation. He is saying that there is a difference of 8 years. He wants to show that some increment should be there. It is not that 1995 is the same, 2003. Now, what should be that increasing that percentage that we have to be searched. Instead of that, you are relying something else. Yes. Yes. Yes, read. Yes, read.
Primarily, the increase of land prices depends on 4 factors. Situation of land, nature of the development in surrounding area, availability of land for development in the area, and demand for land in the area. In rural areas, unless there is any aspect of development in the vicinity, increase in prices is slow, steady, and gradual without any sudden spurt or jumps. On the other hand, in urban or semi-urban areas, where the development is faster, when the demand for land is high, and where there is a construction activity all around, the escalation in market value price is at much higher rate as compared with rural areas. In some pockets in big cities, due to rapid development and high demand for land, the escalation in prices have touched even 30% to 50%. Or more per year during the 90s. So taking into consideration.
You read paragraph, read next.
Land acquired under this condition, 20
Faridabad town ಒಳಗಡೆ ಇರೋದು. Yes. Yes, yes.
These places land in 1980s. The records are suggested the Secretariat and several other commercial complexes they were just opposite the land acquired during the period on the basis of the above factors. We are looking at 1% per annum relative increase of this.
Yes.
Then we graduate on the land acquired under notification dated in June 1982.
Yes.
Respect of the land acquired under the notification July 1995, and the claimants should be entitled for government to consider out of commitment is 12% per annum on the year 1926 to the year 1927. So this was our various case because founded the note of caution in the option of annual increase method to be applied for a few years. This was taking into account of the actions is applied for the community increase of 8 years. Which was straight from Punjab. The 6 and 9 years as it is on all and an overall of tax and the we are of the view that the community increase rate of 1% per annum from 1986 to 1995 is best practice. Now our case is 95 to 2003. 12% at least.
Yes, that's all. Yes, madam. What is it? But
% is
yes. The appeal is filed. The section 54(1) of Land Acquisition Act by the claimant challenging by the claimant for enhancement of compensation granted by First Appellate Court. Now that this is the reference court order. Yes, granted by the reference court. By award dated 1910-2010. Claimants are the owner of the land at Vadara Bilugalli village, Piriyapatna Taluk, measuring 32 guntas in survey number 65/1. How many claimants are there? Who is that? Wait, madam. Don't make confused. Yes.
Number 67.
LIC number 67. Yes. 1 acre 1 acre 10 guntas in survey number 66/1. Has been acquired under a preliminary notification dated 13/3/2003 for the purpose of Piriyapatna lift irrigation. The land acquisition officer has passed an award on 17/1/2004, determining the market value of the acquired land is rupees 36,800 per acre. Being agreed by the same, claimant has filed an application under section 18(1) of Land Acquisition Act. The same has been referred to the reference code and it has been numbered as LAC 67 of 2009. On consideration of the evidence of the parties material available on record, the reference code has enhanced the compensation from 36,800 per acre to 62,060 rupees per acre. 60 rupees per acre. Being agreed by the same, the claimant has filed this appeal. So and so learned counsel appearing for the claimant has contended that for the very same purpose, the adjacent land in the very same village has been acquired by the respondent by preliminary notification dated 7/12/2019-95. The reference code in LAC number 89 of 2017 has enhanced the compensation, has determined the value rupees 7,26,920 per acre. By judgment dated 16 September 2017. Hence, 16/9/2017. Hence, he contended that the claimant is also entitled for enhancement of compensation in terms of award passed by the reference court in LAC number 89 of 2017, and further contended that since the preliminary notification in the case in hand has been issued on 13/3/2003, court has to award additional percentage of cumulative annual increasing the value of the property. He contended that apex court, he has relied on judgment of apex court in case of acquainted relator LLP ETC versus State of Haryana and others, civil appeal number 1330-1332 of 2021. While the apex court has increased 8% in the market value, hence he sought for increasing in the annual market value of the property has to be considered. Per contra, so and so learned counsel appearing for government has contended that has not disputed that in adjacent property which has been acquired for the very same purpose by a preliminary notification dated 7/12/1995. The reference court in LAC 18N of 2017 has awarded 7,26,920 per acre. She contended that nominal increment can be increased, nominal percentage of increment can be increased while granting by enhancing that compensation. Heard the learned counsel for the parties. Feroz. Original records. It is not in dispute. Claimant is the owner of the property. Bearing survey number 66/1. Situated in Paidara village, Piriyapatna Taluk, measuring 1 acre, 10 guntas. It is also not in dispute. Same has been acquired by the respondent for the purpose of Piriyapatna lift irrigation under preliminary notification dated 13/3/2001. The award was passed on 17/1/2004, determining the market value of the acquired land is 36,800 per acre. The reference court has enhanced the compensation to 62,060 per acre. Learned counsel for the appellant claimant has produced judgment passed by reference court in LAC number 89 of 2017, acquired by the very same purpose by the respondent under preliminary notification dated 7/12/1995. The said case, reference court has enhanced the compensation from 10,482 7,26,920. Is there any appeal against this order? Yes. It is submitted by learned counsel for the petitioner that claims that judgment is attained finality. Respondent has not challenged the same. In respect of grant of compensation by the reference court in LAC number 89 of 2017, adjacent property of the claimant has not been disputed by the government pleader, so-and-so government pleader. Under these circumstances, the market value per acre has to be considered as 7,26,920. The apex code In case of Balwant Singh versus State of Haryana and others, civil appeal number 2736 of 2019. Para 18 as extracted. Para 18 and 8. Considering that above observation, land in dispute has been acquired for a irrigation project, which is an agriculture land situated in the village. I am of the opinion that the climate is further entitled for increment of increasing 5% per annum over the market value. Accordingly, 5% ಆದ್ರೆ ಎಷ್ಟಾಗುತ್ತೆ? ಒಂದು ಎಕರೆಗೆ 7,26,920 ಗೆ 5% ಆದ್ರೆ ಅಲ್ಲ, ಅಲ್ಲಿಗೆ ಎಷ್ಟಾಯ್ತು? 7,26,920 ಶೇರ್ ಎಷ್ಟಾಯ್ತು? 7,26,920.
7,63,266.
That market value of the into 5 years already. ಒಂದು ವರ್ಷಕ್ಕೆ 36,000 ಜಾಸ್ತಿ. ಏನ್ ಟ್ಯಾಕ್ಸ್ ಕೊಡ್ತಾರೆ?
6,000 into 8 years. 2,88,000.
The market value of the land has to be determined as 9 lakh is round up as 9,26,920. Huh? 10 lakh is per 2,80,000.
2,88,000.
Now, the round up, we will make it as 10 lakhs per acre. Accordingly, by taking consideration the above, I am of the opinion that the market value of the acquired land is to be determined as 10 lakhs per acre. In addition, claimant is entitled for 30% solacium on the enhanced market value, and all consequential benefits. Accordingly, the appeal is disposed of. Accordingly, the appeal is allowed in part. The compensation has to be enhanced from 62,006 to 10 lakhs per acre with all other consequential benefits. Pending applications are disclosed. Yes, the appellant is not entitled for the interest for a delayed period of also day. Yes.
Ramesh, K.K. Manjunath, application at number 65.
None appear reach this matter of election. Dirty days, ಯಾವ್ದಾರ?
ರೇಟ್ ಇದೆ ಅದ್ರ.
Yeah.
92 ಒಂದಿರ್ಬೇಕು. ಹಾಗೆ ಒಂದು ಹೋಗಿರುತ್ತೆ CRP.
ಬೆಳಿಗ್ಗೆ ಒಂದಿತ್ತ?
23.
ಡೇಟ್ ಬರ್ತಾರೇನ್ರಿ? ಇವತ್ತು ಡೇಟ್ ಬೆಳಿಗ್ಗೆ ಒಂದಿತ್ತಂತಲ್ಲ?
ಏನಂತ ಹೇಳ್ಬೇಕು ಸರ್, ಆಪರೇಟಿವ್ ಪರ್ಸನ್
ನೋಡಿಲ್ಲ ಫೈಲ್ ಹೋಗಿದೆಯೇನೋ ಗೊತ್ತಿಲ್ಲಲ್ಲ. MSc ಇದೊಂದಿದೆ. ಡೇಟ್ ಹೋಗಿಲ್ಲ ಅನಿಸ್ತದೆ.
ಬೆಳಗ್ಗೆ CRP 323 of 21. ಇವಾಗ MSA 92 of 21. $92 ಸಿಗ್ತಾನಪ್ಪ ಇವಾಗ. ಅವಾಗ ಫೋನ್ ಕಟ್ಟೋದು ಅಲ್ಲಿಗೆ ಮರ್ಜ್ ಆಗುತ್ತೆ. ಸರಿ, ನಾನು ಡಿಕ್ಟೇಷನ್ ಅಲ್ಲಿ ಬಂದಿಲ್ಲ, ಸಾಹೇಬ್ರು ಕೇಳ್ಬಿಟ್ಟು ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು. ಹೌದು, ನಮ್ಗೆ ಇದು ಹೊಸ್ತಲ್ಲ. ಸರಿ ಸರ್, ನಾನು ಅವ್ರ ಗಮನಕ್ಕೆ ತಂದಿದ್ದೀನಿ. ಸಾಹೇಬ್ರು ಇನ್ನೂ ರೀಚ್ ಆಗಿಲ್ಲ ಅಲ್ಲಿ, ಮೋಸ್ಟ್ ಬೇರೆ ಚೇಂಬರ್ ಅಲ್ಲಿ ಇರ್ಬೋದು. ಬಂದ್ಮೇಲೆ ಕೇಳ್ಬಿಟ್ಟು ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು. ನಾಳೆ ಒಂದ್ಸಲ ಮಾತಾಡ್ತೀನಿ. ಬೇಡ ಬೇಡ ಲಾಸ್ಟ್ ಫೈನಲ್ ಆದ್ರೆ ಕೇಳ್ಬಿಡ್ಬೇಕಾಗ್ತಿಲ್ಲ.